it and then remove me because say this is false allegation you've leveled, you don't fit to be a judge, and not only made a false allegation, you went and made it publicly. That's, you would imagine, if it was false, he should be removed. If it was false, he should be removed.
No.
No, if the allegation that you make now,
yes,
is established to be false after the inquiry.
After the inquiry, yes.
Should you have been removed?
Then can be yes.
Okay.
Then that
no. Now I reverse it.
Yeah.
If after inquiry it transpires that the allegation that you leveled was true,
yes,
they may say you still should be removed because you went public. Or, no, you should not be, but your emphasis is on the fact that one way or the other, inquire into the matter. Am I correct in understanding that? Now because you had leveled initially allegations without making anyone a party, so we wanted to hear what the persons against whom the allegations had been made, what would they say? They may come and say, yes, I did so, but there was nothing wrong in it, or simply say, yes, I did it. But the matter can't end now because they're saying, no, this is all false. So who will ascertain the truth of the matter?
The Supreme Judicial Council ought to have done that. My position is. Now your Lordship is.
Zara mein solution bhi bata dena sir. We are looking for how to solve this riddle.
इसका simple जवाब है sir. जैसे पहले, in some cases it has happened. तो ये है कि हमने begin with
हमें solution, हम आपका point of view समझ गए, हम आपका केस समझ गए. अब हम करें क्या ये बताइए. What sort of order which should not, either then it will amount to the same allegation that you leveled on the other side. The other side will tomorrow complain and say, you never ascertained this fact, and you've held that we've done this thing. So, you come up with a solution now.
Sir, my solution is yes. Let this order of the President and the report may kindly be quashed, and a commission may be appointed to ascertain the truth, so that we can cross-examine them, they can cross-examine us.
Commission, how, under what law will we do that?
This Honorable Court can always do so.
No, they can't.
To ascertain the truth about the matter.
No, it can't be remanded to the Supreme Judicial Council.
Sir,
is that a possibility or it's not?
It can be, yes. It can be, yes. It can.
No, I want your clear thinking on this.
After questioning the order of
Sub-Article 7,
there is one problem which I see.
एक Sub-Article 7 भी पढ़ ले. 209 Sub-Article 7. 209 Sub-Article 7 पढ़ ले.
जी 7 साहब वो 7 की बात हो रही है ना, तो उसमें है a judge of the Supreme Court or of a High Court shall not be removed from office except as provided by this article. Article क्या provide करता है? President can remove on the basis of a report. The report has to be based on inquiry. So therefore under clause 7
नहीं देखें, ये तो admitted fact हो गया that no one ascertained whether the allegation was factually correct or not. That much is established from what I've been able to understand. Unless somebody says, no, it's not been established. I don't think even Khwaja Sahab, पूछते थे Khwaja Sahab कहाँ गए? Was the one way or the other, whether the allegation was true or not, was it been ascertained or not?
It was never inquired into, it was never ascertained, and if that part of the order would
how do we go forward then on this?
We are very respectfully submit.
Because both can't be telling the truth.
No, quite right.
Yes.
May I very humbly submit, my Lord. The order itself may have two components, although they are mixed up. As far as I'm concerned, they are mixed up in the sense, one is with respect to the public speech that was made. Whether the public speech that was
made, that's a separate aspect.
This is what I'm saying.
That may in itself be such a grave crime that you remove him.
No, I'm making a
or nothing implied in the order is the fact that you've leveled such serious allegations against some people
which cannot be sustained because no inquiry was held. That portion.
What is the solution here?
May I very respect, this is what I was saying, Madam. May I very respectfully submit the order itself is composed of these two components. One is that a public speech was made. The other is that there was an allegation made or there were some assertions made which were not inquired into, and that was also held against the petitioner. Now that portion cannot be held against the petitioner so far as the STC order is concerned, because that was never inquired into. We are only then left, as far as this list is concerned, only left with the question whether the public speech that was made was
नहीं देखिए उसका बड़े implication होगा. I think let's live in the real world. The entire eyes of the nation are before us. There are 2-3 constitutional offices involved. One is at stake is the independence of the judiciary. If I'm sure you will also agree that no judge should be removed without cause. I'm sure you will say that.
Yes, right. That's true.
That's one aspect. The other aspect is there's another constitutional body involved called the Supreme Judicial Council. Now, ordinarily, the Supreme Court should not interfere in the work of another constitutional body unless there is something so manifestly unconstitutional or unjust. What Mr. Hamid Khan Sahab is saying is there was no inquiry held, and you are conceding it, and the Attorney General is also conceding it. Needless to say, if the statement made was false, he also concedes that the judge should have been removed. The third issue is the Supreme Court itself.
Very well written judgment.
We are hearing this case. Now the question arises, what sort of order we can pass in such circumstances. And I think there's an interconnected, when the Attorney General wants to argue, we have no issue.
I'll stick to the constitutional questions arising out of this case.
Opinion to page 70 So opinion of the Supreme Judicial Council.
Yes.
Page 70 pe hai.
70 pe. Yes. Conclusion, sir. This council is unanimously of the opinion, kindly see here, that in the matter of making his speech before the District Bar Association Rawalpindi on 21/7/2018, Mr. Justice Shoukat Aziz Siddiqui, Judge Islamabad High Court Islamabad, had displayed conduct unbecoming of a judge of a High Court and was thus guilty of misconduct, and he is therefore liable to be removed from the office under Article 2096 of the Constitution of the Islamic Republic of Pakistan. 2096, which says you inquire into the matter, which was never done. The other portion of this you also may find very relevant is on page 4950, where they decided to dispense with the inquiry.
Has any jurisdiction to question, probe, and adjudicate the intra-party elections of PTA? Suppose allegation दुरुस्त है, suppose क्या ये जिस तरीके से allegation बयान की गई हैं, जिस तरीके से तकरीर क्या ये एक जज के लिए मुनासिब था?
Thank you, sir.
ये बता रहा हूँ आपको ये दो पॉइंट
I fully understand that, and I think my arguments will be limited to those also. Because I think I'm also running against time. Today is the last day for
You are running against time, but we have another edition. Actually write an order.
That is always the
two kinds of speeches. I mean,
we lawyers can get away with speech. We just argue and leave.
I think we should not forget the facts.
My submission, first of all,
the fact is not making the speech. If it's making the speech, then probably half the superior judiciary respondents will have to go home.
All of them.
Because how many judges have made to the Bar Council
will supplement on constitutional points.
These are not two
points there.
So
that's
it's not a question of points will be as follows of a speech. It's the content of the speech. I think both go together. Now it depends what I say. If I say that should be, I go and tomorrow I make speeches, depends on the judiciary. Fine. I may even canvass a view which is different.
Representing
But if
1, 2, 3, 4, who all do you represent?
Ji.
For response, because we have to write in our order, for respondent numbers.
Petition then.
Page 1 pe, array of the parties is there. I don't.
Your Lordships, I represent 1 to 8.
1 to 8. And what about 9 and onwards?
They are the.
No, just run through the names. We don't want to make a mistake.
Raja, Tahir, Nawaz, Abbasi.
No, just read to yourself.
Right. Pakistan Tehreek-e-Insaf.
No. 1 to 8 you represent. 8 onwards you don't represent.
8 onwards I don't represent.
Up to 22.
To 22.
You represent, then they've added pro forma respondents. You don't represent them.
I don't represent them.
Okay, fine. Chale, please proceed. Sorry, I'll just be nudging you along because there is a timeline.
Absolutely. I'll in fact appreciate that because I've formulated some points with the view of timing, and I know that your Lordship has to write a judgment. So my first proposition, your Lord, my propositions are about 5 in total. The first proposition is that neither the Constitution nor the Election Act 2017 gives ECP any jurisdiction or power to scrutinize intra-party elections and declare them void, and further to deny the electoral symbol, common electoral symbol, to a political party on the basis of any alleged irregularities in the intra-party elections. That is my point number 1 I'll be arguing on. Point number 2, Your Lordship, is that under Article 17(2) of the Constitution, the right to form political parties is guaranteed, and over the years the Supreme Court has robustly interpreted Article 17(2) to not just forming but also operating as a political party. Contesting elections with a unified symbol falls squarely within this right. And denying an electoral symbol.
Just slow down. Contesting elections with a unified
symbol falls squarely.
Unified
symbol falls
with a unified
symbol falls squarely within this right. Denying an electoral symbol.
The third point or the same?
Same one. Just ending, closing it now.
This right.
Denying an electoral symbol based on alleged irregularities in intra-party elections is a violation of Article 17(2) and an unreasonable restriction, and hence void. The third ground, Your Lordship, connected with this is that the interpretation of the provisions of the Election Act proposed by the ECP would amount to a violation of Article 17(2) and hence is incorrect. My third point is, Your Lordship, fourth one, that the Constitution states that the Election Commission is not a court of law. And if its orders are contrary to facts or arbitrary and even unreasonable, then they are subject to judicial review. The fifth point is, Your Lordship, then my argument will be based on is that ECP has acted in a discriminatory manner.
Has acted in?
A discriminatory manner in violation of Article 25, and its mala fide is apparent on the face. Mala fide in law and facts is apparent. My next point will be, Your Lordship, that since the fundamental question involves the civil rights of a political party as well as the individuals, it can only be decided by following the provisions of Article 10A through a fair trial. ECP, not being a court of law, cannot give a fair trial within the meaning of Article 10A. And in fact, no such trial took place. And last thing I'll be arguing is, Your Lordship, that none of the members of the PTI have filed or challenged the elections. They can only dispute this matter before a civil court, because PTI is a political party which is a private association of citizens, and the ECP has no suo motu jurisdiction to become a complainant and adjudicator in one. So these are my grounds that I'll be. And lastly, I will say that on merits, I followed the constitution of PTI and held the intra-party elections. This is going to be the parameters of my arguments, Your Lordship. Now, Your Lordship, we'll see. Your Lordship will see that the election, the brief facts that I'll be discussing only to start with are as follows. ECP, in fact, I'll start by saying that PTI held its elections on 8th of June 2022. Your Lordship may call them the first election. And ECP vide its order dated 23rd of October 23. Directed that elections be held within 90 days. They said these elections are void and you should hold new elections in 20 days. Why they said that may not be relevant to this case, but I'll briefly inform the court. They said this because, according to them, the council that had made the amendment under which the elections were held, the council was not valid. It was not functional, according to them.
What do you mean by council?
The executive council of the PTI.
PTI.
So we had 20 days, and at the same time, Your Lordship remembers, round about that time, Your Lordship had decided that the elections will be held on 8th of February.
When was that?
Through a judgment that Your Lordship.
What was the date?
I'll just find out the date. I'll just find out the date. And so there was time constraint. We had 20 days and we were very scared, I may add, that if we don't hold the elections, then Election Commission of Pakistan may take action against the party and keep it out of the politics and the elections. So we decided that while we will be challenging the vires of that order, we should also comply. And so, Your Lordship, we held the elections the second elections, the second intra-party elections on 2nd of October 2023.
Second of October or December?
2nd of December, sorry. 2nd of December. These elections, Your Lordship, were called in question. We filed the forms 65, which is the requirement. We filed all the documents. But then 14 persons who alleged that they were members filed applications before the Election Commission. And in those applications they said that these elections should be declared void and there should be re-election. This was their prayer. There should be re-election.
Complaints are on record?
They are on record. Your Lordship, the ECP also raised simultaneously some technical points. These technical points related to dates, signatures, forms. That the signature is not right, please put a signature here. The date is not right, please put a date there. A notice was served on us that please come in. There's a hearing for on the basis of these 14 applications. A hearing took place, and our basic stance was that these are not members.
Did you respond in writing or verbally?
Verbally.
When was the hearing?
It is mentioned in that order. It was 18th.
18th of?
December. So, Your Lordship, on the date that the hearing was finished, the Election Commission handed over 32 questions to us, that these are our questions.
Where are those?
Those are also on record.
Page?
A page, I think it's page. I'll just come to those pages in a minute, but I'm just giving a brief. Now, Your Lordship, the 32 questions were also answered in writing by us. And then the Election Commission of Pakistan passed this order dated 22nd 12/2023, in which two things happened. Number one, the election, intra-party election, was declared void. It was set aside by ECP. And then on this basis, the ECP went on to do a second thing, which is that it ordered that the symbol will not be given to PTI. Now, Your Lordship, this order in 22nd 12/2023 has been read before this Honorable Court. But I'd like to summarize what I think is the reading of that. Number one, the impugned order has decided that the intra-party election was held. This is important. Was held on 2nd of October 2023.
December,
sorry, I keep saying October. December 2023. So it was held, they say. They're not denying that it was not held. Number two, they have not pointed out anything in the manner and conduct of the election itself. No irregularity or defect per se in the manner and conduct of that election has been pointed out. Number three, they have accepted that Form 65 and all the documents as required by Section 209 have been duly provided. These three things are important for my arguments. IP was held, they have not pointed out anything, so I don't need to go into many aspects of the election itself. And no documentary dispute. But what they have done, Your Lordship, is given a very circular reasoning, which I call a circular reasoning fallacy. A circular reasoning fallacy, which is actually an absurd reasoning. They have said that your intra-party election is okay, but the General Secretary who appointed the Chief Federal Commission, that is the person who conducted the election, was not properly appointed. And because the Federal Commission was not properly appointed, therefore the intra-party election is irregular. And because it is irregular, we do not accept this election. And because we do not accept the election, we will not give you the symbol. Huge jump, Your Lordship. Huge jump. Taking away the symbol because of an irregularity in the appointment of a General Secretary who appointed a Federal Commission.
If I may interrupt you. Yesterday, Mr. Makhdoom Ali Khan was arguing on the technical aspects, Secretary General and all that. And I may repeat for your benefit, that the more fundamental question is whether there is democracy in the party, which can only be reflected by an election, valid elections being held within the party. And if that is so, then everything follows. Then you get the symbol, whatever other requirements are. And if that is not, then you run into trouble. So that is at least, if I'm speaking, I speak for myself, my focus will be, if you're talking about democracy, then there must be democracy within political parties as well. So the whole conduct of the elections, not the fine aspects of the elections, here as irregularity or there irregularity, but the fundamental point of an elections may not have complied with all the rules and regulations of the PTI's constitution, which is not really the concern of the courts, nor should be of the Election Commission of Pakistan. But the fundamental question cannot be ignored, that members had been granted a fair opportunity to file nomination papers, to contest the election, and there was a semblance of regularity. That much, overcome that much.
I've got that point. And
by simply saying 14 persons came as complainants and said, we are not being allowed to participate in the elections, to simply discard them by saying they are not members of PTI will not be sufficient, when at least for one of them, Mr. Akbar S. Ahmed, it has been admitted that he was a founding member of the party. Merely because you don't like what a person says does not mean that his membership ceases. Unless you can show he resigned a political party, joined another political party, or went through some disciplinary procedure and was thrown out from the political party. So I don't know about the other candidates, we've not heard much about them, but don't just simply say they were not members of PTI. How would I know you are a member of PTI? You saying so and they saying so. There must be some parameters within which one can objectively determine this fact.
Absolutely.
So if it is not added to this, and please hear this is also very important, you used the word mala fide in fact and in law. Various allegations, we don't try to be influenced by anything that is said on the media or social media, but your stance is that there is mala fide of fact and law before the court of law, the Supreme Court. Now you must show such mala fide, because a point which was raised yesterday by Mr. Makhdoom Ali Khan was the fact that, okay, now I'm not in government, now they are hounding me. He said, no, we had raised this point when you were in government. PTI was in government. ECP was a constitutional body and had called upon you to conduct your elections. This has gone back very far back in time when the PTI was in government. So surely, unless you are saying that ECP was so independent a body that even it was proceeding against those in government then, either you maintain that stance that will undermine your stance that ECP has suddenly, the same persons in the ECP have suddenly turned subservient to whoever you want to allege. So, if it was suddenly been brought up, they've been pursuing this matter for quite a while. And before that, either you take the plea that the law of election, and mind you, Election Act has not been challenged, any provision thereof.
I will not.
So whether we will not comment on its constitutionality because it has not been challenged. It may be challenged tomorrow, and we don't want to, in these related proceedings.
I'm not challenging them.
So certain provisions were pointed out, then a person will just produce a piece of paper, I've held elections. And would that constitute elections? I'm not going into the nitty-gritty of the elections, mind you. I want to know the general, every election everybody complains. I mean, it's rare in Pakistan that nobody complains, but you see the general
broader picture.
So you understood what I
mean? I have understood. And I'm going to address that. I worked on it last night, and I will address both those questions. So, but for the present moment,
Let me start with the facts first. Then we come. If we can just start with 14 members.
Destroy my scheme of arguments.
Okay, fine. Okay. Fair enough.
Page 90 के ऊपर
आप जैसे चलें फिर आप चलें.
फेडरल इलेक्शन कमीशन का आपका शेड्यूल है पेज 90 पेपर बुक नंबर 1 में.
जी.
तो ये आप जरा देखिए ना, इसके अंदर जो नॉमिनेशन और इलेक्शन कराने का तरीक़ेकार पेज 90
जी. हमने जो पेज 90
आपके नियाजुल्लाह खान नियाजी साहब ने 29/11/2023 को इशू किया
जी.
अगर आप इसमें देखें, नोटिस इनवाइटिंग नॉमिनेशन पेपर्स फ्रॉम पीटीआई मेंबर.
जी सर,
ये वही है 29/11
हो गया जी 29 को.
फिर नॉमिनेशन फॉर्म्स टू बी रिसीव्ड बाय रिटर्निंग ऑफिसर एट इस्लामाबाद जस्ट आफ्टर 2 days 1/12/2023.
करेक्ट सर.
अपील अगेंस्ट ऑब्जेक्शन और रिजेक्शन ऑफ नॉमिनेशन फॉर्म वो भी पहली तारीख ही, सेम डे ही नॉमिनेशन फॉर्म रिसीव किए जाएंगे, सेम डेट ही वो अपीलें फाइल हो जाएंगी. फिर डिस्प्ले ऑफ नेम ऑफ कंटेस्टिंग पैनल वो भी 1/12 ही है
जी.
फिर पोलिंग डे एट पेशावर खैबर पख्तूनख्वा, इसमें देयर इज नो वेन्यू मेंशन फॉर द इलेक्शंस, दैट इज ये भी 2/12/2023 को ही होगी. फिर डिक्लेरेशन ऑफ इलेक्शन रिजल्ट बाय सीईसी वो भी 2/12 को ही होगी. और नोटिफिकेशन ऑफ इलेक्शन रिजल्ट जो है वो 3/12 को होगी. जस्ट ट्राइंग टू अंडरस्टैंड यस्टरडे ऑल्सो कि जो आपका प्रोसीजर है इसके अंदर वो नॉमिनेशन फॉर्म कहाँ से लेने थे, वेयर वॉज द वेन्यू मेंशन इन दिस, how to collect the form, nomination form, where the nomination form is to be submitted, because I also asked the question that how many members you have. I think it is more than 8,50,000. तो इसके अंदर जो बात चीफ साहब भी आपसे कह रहे हैं कि वो ट्रांसपेरेंसी इलेक्शंस के अंदर थी, कौन लड़ सकता था कौन नहीं लड़ सकता था, by simply saying अब आपकी 15 कंप्लेंट वहाँ गई हैं ईसीपी में जी. ECP में सो मोटो नहीं है ये एक्शन. Somebody has filed a complaints and the action was taken on the complaint not by ECP सो मोटो आपके अपने सर्टिफिकेट 65 पे नहीं हुआ है कि 15 कंप्लेंट फाइल हो गई वहाँ पे, तो अब उन्होंने देखा है इन सब चीज़ों को, तो उस पे हम ये पूछना आपसे चाह रहे थे ना कि ये किस तरह का प्रोसीजर था।
बिल्कुल, मुझे आई अंडरस्टूड द पॉइंट, आपका जो पॉइंट है,
क्योंकि जब आप लेवल प्लेइंग फील्ड की बात करते हैं तो आपकी पार्टी में भी तो लेवल प्लेइंग फील्ड होनी चाहिए ना, जब वो मेंबर्स को भी तो लेवल प्लेइंग फील्ड मिलेगी जो करना चाहता है इलेक्शन। जैसे चीफ साहब ने डेमोक्रेसी की बात की, तो मैं ये बात भी आप उसमें ऐड कर रहा हूँ कि उनको भी तो मौका मिलना चाहिए ना।
मैं
जीते हारे वो उनकी नसीब में इलेक्ट होते नहीं होते हैं, और फिर सारा दारोमदार आपके अपने PTI के कॉन्स्टिट्यूशन पे है, उसमें आपने इतना ट्रांसपेरेंट प्रोसीजर बनाया हुआ है कि वो दैट्स वेरी गुड कि आप उसमें सारी चीजें, बट इफ यू फॉलो दैट वुड बी ए बेस्ट ट्रांसपेरेंट इलेक्शन ऑफ एनी पॉलिटिकल पार्टी। अब वो बीच में लैकिंग नजर आ रही है, इसलिए ये सारे सवालात उठ रहे हैं।
बिल्कुल ठीक है सर, मैं आई गॉट दैट।
You may ignore the, with respect to Mr. Makhdoom Ali Khan, he may get upset, but you may ignore the minor points. I mean, we are more focused on this, so I'm just telling you our mind, and we want to save time also.
I appreciate,
because you know every election we will find some more this particular form not submitted, that thing not done. Okay. We will be charitable there.
ठीक जी ठीक. So your lordship, my coming back to my point, so एक order है जो इलेक्शन कमीशन ऑफ पाकिस्तान ने किया जिसमें उन्होंने कहा कि होल्ड हुआ था. They have not pointed out anything in the manner, but I will still satisfy the court जो आपने पूछा, लेकिन they have not pointed this out. They have simply said the appointment of the general secretary and the appointment of the federal commission. So they have not questioned कि आपने एक दिन में क्यों किया या 2 दिन में क्यों किया या अनकंटेस्टेड क्यों था वगैरह वगैरह. So that is important to note कि as far as the election commission is concerned, they have no cavil with this. Your lordship has raised a question which I'll be answering with documents shortly, but for the time being the order does not say it. Now your lordship, they have done 2 things: taken away the not just declared this election void, but also jumped and taken away the symbol. So एक चीज है कि आपका इलेक्शन,
वो तो हमने नोट कर लिया जी. आप प्लीज प्रोसीड.
Now what is a symbol, sir?
I know, we know what a symbol is जी. No,
but a symbol, your lordship, is a fundamental right. I want to point out that.
When you say this, you'll have to back it up.
I will back it up.
We are not denying the importance of symbols. If you want to know, we realize the checkered history of Pakistan and how political parties have been hounded. So I think it started with the elections of the Pakistan People's Party, which let me just
उससे पहले भी जा सकते हैं,
बहुत पहले जा सकते हैं. At least when I was I mean we can go to Ayub Khan and all that, वहाँ से भी जा सकते हैं. But जब पॉलिटिकल पार्टीज वाज़े तौर पे आ गई, अयूब खान का वो तो खैर आप वहाँ जाना चाहें वहाँ चले जाते हैं, मगर इन रीसेंट मेमोरीज एंड दोज पॉलिटिकल पार्टीज विच एग्जिस्ट टुडे, लेट्स पुट इट दिस वे, द फर्स्ट ब्रंट वाज रिसीव्ड बाय द पाकिस्तान पीपल्स पार्टी. The sword was, I think, the symbol. तलवार. फिर वो पहले नॉन पार्टी इलेक्शन ये वो वगैरह हो गया. फिर the second brunt, then the parliamentarians and various other things. Then the second brunt was the Pakistan Muslim League. But be aware of the fact who was in government then. Today, was there a Supreme Court which had taken PCO oaths, judges, any act will not be challenged. So we must bear in mind those were far, far, far more difficult times.
Yes.
There's no comparison. Maybe you can say, yes, it continues today. You may say so. But today, your opponents are not in government.
They're not.
We use the word casually, establishment. Why don't we use the word honestly, army? There does not apparently appear to be any interference. You may allege there is, but you know the overt kind of stuff file. Unless you point out matters are coming, the elections are not being held. It was your own petition we argued, which we pressed it in 12 days. We got the date. You were happy. Everybody was happy. When so access to courts is there. It's not that nobody allowed you to file. Making allegations on the media or outside unnecessarily undermines constitutional institution, which does not mean you should not make these allegations if they are true. Now, the very same election commission has issued you the notice to hold elections as far back when you were in government. Can you start from there? What was the malafide then? Please read that notice, the first one, because that, from a timeline point of view, that will be very important. Because if we have to gauge whether suddenly the euphemism that is used, establishment is weighing heavy on the election commission and doing something, we will certainly hear this. But then, how did they know then, when the very same establishment, surely it was not your allegation then that they were siding with the Election Commission of Pakistan. So if you're going to make it dramatic and political, then give the whole context or keep it legal. So if you're going to use, I mean, I respect every constitutional body. You said malafide in fact and law. Did we appoint them? You all appoint these people. We don't appoint them. So when you just throw an allegation is not acceptable because you don't serve Pakistan then. We need these institutions. We can make them better. If they're not doing their job, force them to do the job. That's our job. But we cannot take on their responsibilities because you'll be the first to complain. We will not take on the responsibilities of Parliament, as I have repeatedly stated. You will be the first to complain. Who is he? I'm the parliamentarian. I'll make the law I want to. We'll judge the law, whether it's constitutional or not, and that's it.
बिल्कुल
सही। दरअसल आप ये मैलिफिडे का जो आप एंगल अगर ले रहे हैं तो इसको सब्सटैंशिएट कीजिए। मैं जिस तरह लूंगा changes the prism completely. Right. If they are malafide, then we look at them at very suspect eyes, or you take away this allegation. I'm not saying take it away. It's your call.
मैं जो I'll be totally non-political in my arguments, Your Lordship, as always. There's no point in bringing, although it's relevant to a political party, this case, but I will keep it very legal. And on the malafide in fact and law, I will be more relying on procedural malafide than anything else. I will not go into...
Are you withdrawing the allegation of malafide in fact? Because it's very important. You have to answer this.
When I use the word malafide in fact, maybe I was wrong in saying in terms of...
you can withdraw it if you want to. Don't withdraw it if you don't want to.
I'm not even going there into that arena. I am basically going to argue that there's a procedural clear cut on the record.
I'm noting that you are withdrawing you're not saying malafide.
I'm not saying malafide in fact.
Please proceed.
In that sense,
you are always fair. Please proceed.
Now, Your Lordship, so I was starting by saying that symbol is a fundamental right of a political party under Article 17, Sub-Article 2. And I am not saying that Your Lordship said back it up. I will back it up with a judgment which is known as the famous symbols case.
Benazir Bhutto case? Ji. I think both parties are relying on the same judgment.
They are not. They are relying on the other Benazir Bhutto judgment of 88. I am relying on the 89 judgment.
So, citation please.
It is PLD 89 Supreme Court.
1989 Supreme Court.
66. It
66.
12 judges sat on this case, and it's basically all about symbol.
Relevant page?
I will just read that relevant page. But before that, Your Lordship, let us look at the effect of no symbol.
No, एक second. देखिए, maybe I at least the fundamental question is, if elections are proper, I for one don't think that you should be deprived of the symbol. So when you're citing Benazir Bhutto, was it a question of inter-party elections or no?
No. It was a question that a symbol was the symbol was being taken away.
You can't just deprive someone of their symbols. But here it is connected with the party elections.
My point
because certification, suppose there is a particular time within which you have to file a certificate. You don't comply with the time. I don't think it's such a relevant thing that a person should be deprived of their fundamental rights or even normal rights. So when we read this judgment, we'll have to consider the fact that it was not a question where the political party had not held elections. Yes, who can deny the importance of a symbol?
But my reason for reading this judgment will be separate, different. My reason for reading this judgment would be to show to this honorable court that a symbol is not just a right of a political party. Symbol is a right of the illiterate millions of people of Pakistan who rely on the symbol for the purposes of exercising their right of vote. They rely on a political party symbol for the purposes of...
Zafar, I think maybe it's too fine a point of what... I don't disagree with you at all. But...
So I will...
No, but पूरी बात सुन लें. मगर मैं कुछ और कह रहा हूँ. जी. एक नाम होता है ना. Political party is a name, but at the end of the day, political party कौन होते हैं? जो लोग उसको कंट्रोल कर रहे हैं. ठीक है. कल कोई जासूस घुस जाए किसी पॉलिटिकल पार्टी में, उसको एक कागज का टुकड़ा पेश कर दें कि जी हम ये पॉलिटिकल पार्टी बन गए. आपकी पार्टी का नहीं कह रहा, कोई और पॉलिटिकल पार्टी. ठीक है. वो उसी के मेंबर आए कि जी इलेक्शन नहीं हुआ, ये कैसे आ गए? तो पॉलिटिकल पार्टी की जब बात आप कर रहे हैं तो पॉलिटिकल पार्टी तो इनएनिमेट ऑब्जेक्ट है. एक नजरिया को रिफ्लेक्ट करती है, एक कुछ लोगों की समझ को रिफ्लेक्ट करती है. हम ये देखना चाहते हैं कि वो तरीकेकार हुआ या नहीं हुआ, और वो एक ही तरीके से हो सकता है इलेक्शन. अगर इलेक्शन या तो आप कहें कि जी पॉलिटिकल पार्टी इलेक्शन करे या ना करे, ये हमारी मर्जी, एक वो अलग मौक़िफ़ है, और ये इसको गायबी करने इलेक्शन को. मगर ये नहीं कह सकते हैं आप कि जी हम कागज का टुकड़ा पेश करें और इलेक्शन हो गए. आप हमें कम से कम मोटी मोटी उसकी जो इलेक्शन में जो बातें होती वो तो हमें दिखा दें कि जी हमने मौका दिया सबको, हमारे पास लोग आए, इतने लोगों ने नॉमिनेशन पेपर फाइल किया, इतने वोट इनको पड़े और इतने वोट इनको. हम ये बैठ करके गिनेंगे नहीं वोट्स, मगर कुछ तो आप हमें पेश कर दें ना. अभी हमारे सामने जो मसला आ रहा है, कम से कम इनका जो एलिगेशन है कि जी ये कागज का टुकड़ा है, ना आपने बताया कि किस जगह इलेक्शन हो रहे हैं. आपने पिशावर का तो जिक्र किया, मगर फिर आपने कोई और जगह जाके कर लिए, चमकनी में. मुझे नहीं पता है, मगर वो पिशावर नहीं है, कोई और जगह है. तो ये जरा बातें जब हम केस लॉ पे एकदम चले जाएंगे ना, तो जरा सा अगर इस पे आप फोकस करें, क्योंकि मेरे ख्याल में इलेक्शन हो गए, फिर आपको जहमत करने की जरूरत नहीं होगी सिंबल पे जाने के लिए. वो आपका मेरे ख्याल में सब्जेक्ट टू व्हाट दे से एक वो नेचुरल इम्प्लीकेशन या राइट हो जाएगा.
बिल्कुल ठीक है सर, मैं अभी आपको उस पे आऊंगा. मैं सिंपली जो मैं आपसे गुजारिश कर रहा हूँ, आई अंडरस्टैंड योर लॉर्डशिप्स कंसर्न अबाउट द इलेक्शन. I will satisfy that.
ECP की order में भी they have certain violations ना.
Not only violation of the appointment.
There are certain violations.
Not
if you want to see page 613 of the paper book, it is in fact page 10 of the order of the ECP. You can read certain paragraphs in which certain violations have been mentioned.
Let us read that order, because I want to be very clear that ECP is not saying that. I've read it.
नहीं उसका नहीं है, वो टोटल कह रहे हैं ना. वो
नहीं, इस तरह नहीं हो सकता सर. They are actually they have taken a very serious point on this. And
ये पढ़िए पहले, आप ये पढ़ लीजिए पैराग्राफ 22.
पेज बताइए प्लीज.
पेज 612 के ऊपर पेपर बुक नंबर 1. नहीं सॉरी, पेपर बुक नंबर 3.
पेपर बुक, ये पेपर बुक. Your Lordship want me to read at which para?
22 से आप आगे चलेंगे तो.
According to the available record, the General Secretary of PTI is Mr. Asad Umar, and nothing in document is available that PTI or any other competent wing of PTI has ever elected Mr. Umar Ayub as Secretary General of PTI. We also fail to find here in PTI Constitution any provision that Chairman of PTI may extend tenure of any office bearers, while the tenure of Chairman itself has expired on 13/6/23. So after target date 13/6/23, Chairman possesses no authority to exercise such power either to control or to extend the tenure of any office bearers. Such eventuality is well defined in the procedures provided under Clause 4 of Article 5 of PTI Constitution, which reads as under. In case of the chairman's position falling vacant due to any reason, the SG shall take additional charge of the office. In the interim, and elections for the chairman's office shall be held within 30 days of position falling vacant. So far 22 is just about appointments. Clause 1 of Article 5 General Provisions of PTI Constitution widely speaks about collective decision making, which reads as under. All decisions shall be taken by the corresponding governing body, executive committee, and other such bodies by a majority of vote. Minimum quorum required for validity shall be 75% for smaller bodies, committees, and 50% for the larger committees, councils of the total membership. Agenda items shall be distributed by the secretary along with invitation notice wherever possible. Clause 1.3 of Article 5 General Provisions of PTI Constitution describes that governing body can take provisional decisions in policy matters where there is enough room to believe that an executive committee meeting could not be convened in time. Again, nothing to do with the election. Thereafter, as mentioned here and above, it was mandatory for the PTI in terms of Clause 1.4 of Article 5 that on expiry of 18 months thereafter the adoption of the PTI Constitution 2015, which has been adopted on 1/5/2019, to appoint the chief organizer who had to use all the powers and functions of the chairman, well mentioned there in Clause 4.2 of Article 5 of the PTI Constitution, already reproduced here and above.
Para 26.
Going through the above mentioned Clause 4 of Article 5 of the PTI Constitution, the PTI General Council, as per record supplied here to the Commission, adopted and approved the Constitution 2019 on 1/5/2019, and thereafter 18 months constitutionally the PTI is deemed to be run by chief organizer till the announcement of intra-party election of the federal EC, by the federal EC. However, it would be the chief organizer to nominate various members and constitute various committees in interim period. Thereafter 18 months of adoption of PTI Constitution 2019 and first intra-party election scheduled on 13/6/21. As the chairman of PTI never opted to hold intra-party election till 10/6/22, just 3 days before the target date of the intra-party election provided thereunder, Section 208 of the Election Act 2017, however, as the said election was not found to be held in accordance with PTI Constitution 2019, declared void by this Commission. As discussed here and above, in accordance with Clause 4 of Article 5 of PTI Constitution 2019, all powers to organize PTI vests and deemed to vest in the chief organizer, which according to their available record has never been appointed so far. While according to Constitution of PTI 2019, no other office bearer has the authority and power to appoint or nominate any other office bearer, particularly Federal Election Commission. So far, it is all about appointments. The available record submitted by PTI herein before the Commission never provided any document that any competent authority had ever appointed Federal Election Commission in accordance with the provisions of Article 9 of PTI Constitution 2019. Only appointment of a single Federal Election Commissioner is not requirement of Article 9 of the PTI Constitution, and such a solitary office bearer could not exercise any power to hold PTI intra-party election till the Commission as a whole, not appointed by a competent authority provided there under Article 9 of the PTI Constitution. However, Federal Election Commissioner may frame and make bylaws only for the purpose to conduct his day-to-day affairs and working, subject to notify the same on website. But no authority has been provided there under PTI Constitution that apart from Constitution, bylaws or rules will also be made. Even if it is admitted that PTI made some rules for internal affairs, it could not supersede the basic document that is Constitution of PTI, where a specific procedures provide for appointment of election commissioner, and particularly office bearer, then any rule made in contravention of such provision of Constitution has no any legal sanctity and could not be given effect thereto. So, keeping in view the clear mandate of Election Act 2017 read with PTI Constitution 2019, and for reasons mentioned here and above, it is held that PTI has not complied with our directions rendered therein, order dated 23rd November, and failed to hold intra-party election according to PTI prevailing Constitution 2019 and Election Act 2017 and Election Rules 2017. Therefore, the certificate dated 4 December 23 and Form 65 filed by the alleged chairman is hereby regretted and rejected accordingly. The provisions of Section 215 of the Election Act 2017 are hereby invoked, and PTI is hereby declared ineligible to obtain the election symbol for which they have applied for. So they have not gone into
efficiencies उन्होंने बताई हैं ये they have taken from your own constitution. ये election act में नहीं कहा कि ये हम आपसे कह रहे हैं. They have just pointed out deficiencies in election and appointment of Federal Election Commission from your own constitution.
Correct. میں یہ کہہ رہا ہوں ایگزیکٹلی وہی آپ نے فرمایا تھا کہ they have pointed out other irregularities. میں آپ کو کہہ رہا ہوں کہ جو الیکشن کمیشن نے پوائنٹ آؤٹ کیا ہے صرف اور صرف اپوائنٹمنٹس کے بیسس پہ کیا ہے, ناٹ آن دا کوشچن کہ آپ نے کہاں وینیو کہاں تھا, ناٹ آن دا کوشچن کہ آپ کی شیڈیول.
علی ظفر صاحب
جی, دیٹ از واٹ آئی ایم سیئنگ.
نہیں, میں آپ کی بات سمجھ گیا ہوں, مگر آپ ہماری بات سمجھیں نا.
جی, آپ کی بات میں سمجھ رہا ہوں.
نہیں, میں کہہ رہا ہوں دیکھیں, میں ایک نتیجے پہ پہنچنے کے لیے میں ایک طریقے سے ججمنٹ لکھ دوں,
جی,
میرے ساتھی وہی نتیجے پہ پہنچنے کے لیے دوسرے طریقے سے ججمنٹ بھی لکھ سکتے ہیں. مجھے صرف یہ دیکھنا ہے کہ جو نتیجے پہ ہم پہنچے ہیں وہ صحیح تھا یا نہیں. اب وہ ہائپر ٹیکنیکل چلے جائیں یا وہ آئین کی بات کریں یا وہ بے نظیر بھٹو کے کیس کی بات کریں, وہ سارے راہ ہیں. نتیجہ کیا تھا؟ نتیجہ سمپل سا تھا کہ الیکشن کیسے ہوئے. ٹھیک ہے, آپ نے اب سمپل سی بات تھی, اکبر ایس احمد صاحب اگر اتنے ہی ان کی سپورٹ نہیں ہے, ہار جاتے الیکشن, اور کیا ہوتا. ٹھیک ہے, تو یہ بنیادی بات ہمیں دیکھنا ہے کہ الیکشن ہوئے یعنی آپ کی پارٹی میں. آپ یہ نہیں کہہ سکتے کہ, اور یہ اس کی اہمیت, اب یہ ہم بات کرنا چاہیں گے, اس کی اہمیت اس لیے بھی بڑھ جاتی ہے کیونکہ جو آپ کے فاؤنڈنگ ممبر ہیں وہ فی الحال جیل میں فیسنگ ٹرائل. تو کل تو کہ یہ لوگ کون ہیں ہمارے سامنے کھڑے ہیں؟ یا تو آپ ہمیں دکھائیں کہ آپ لوگ فاؤنڈنگ ممبرز تھے. ٹھیک ہے, وہ ایک فاؤنڈنگ ممبر کہہ رہا ہے کہ جی مجھے الیکشن تک نہیں لڑنے دے رہے ہیں, شاید بہت برا ہو, آپ کو نہیں پسند ہو, مگر وہ الیکشن کو اس کو رائٹ تو دے دینا. ایک طرف آپ کہہ رہے ہیں مجھے پارٹی کو الیکشن لڑنے دیں, وہ آپ کے اندر گھر والا کہہ رہا ہے تو مجھے تو کرنے دو نا, میں کیوں نہ پارٹی کا ہیڈ بن جاؤں. Maybe he wants to be chairman, maybe he wants to be whatever secretary general. ہار جائے جیت جائے, اگر آپ کے 8.5 لاکھ ممبر ہیں ان کو پہ بھروسہ کیوں نہیں کر رہے ہیں یہ بتا دیں. اور اگر آپ نے کر دیا ہے بھروسہ, وہ ہمیں کچھ تو دکھا دیں نا ہمیں کہ واقعی کچھ ہوا تھا. کاغذ کا ٹکڑا, کل سپوز اکبر ایس احمد ایک کاغذ کا ٹکڑا لے آتے ہیں, اس پہ آپ کی پارٹی کا نام ٹائپ کر دیتے ہیں اور اپنے آپ کو اپوائنٹ کر دیتے ہیں اور الیکشن اپنا نام لکھ دیتے ہیں انپوز. تو ہمارے پاس 2 کاغذ کے ٹکڑے ہوں گے, کس کو ہم مانیں گے؟ تو پھر آپ ہمیں بتائیں گے نہیں انہوں نے تو گھر میں بیٹھ کے کر دیا, میں نے تو جا کے الیکشن نامینیشن پیپر تھا, اتنے لوگوں نے نامینیشن پیپر دیا, اتنے ووٹر آئے تھے. تو یہ ہمارا مسئلہ ہے.
آپ کا پوائنٹ بالکل سمجھ چکا ہوں سر, میں آپ نے پہلے بھی ریپیٹ کیا. میں
اب وہ اس طرح سے چلا گیا الیکشن کمیشن یا اس طرف.
میں بالکل, میرا خالی پوائنٹ یہ تھا کہ ابھی میں یہ کہنا چاہ رہا تھا کہ
کیونکہ ہم تو بڑے آپ کے کانسٹیٹیوشن سے متاثر ہوئے کہ آپ الیکشن, آپ پولیٹیکل پارٹیز کو آپ ڈیموکریٹک بنا رہے ہیں.
آپ کی بالکل بجا بات ہے, لیکن الیکشن کمیشن اس طرف نہیں گیا. دیٹ از آل دی پوائنٹ آئی ایم ٹرائنگ ٹو میک. سو کمنگ ٹو دی سمبل سے
ظفر صاحب, جسٹ وانٹ ٹو ایڈ سم تھنگ. یہ جو ججمنٹ از امپیون بیفور اس
has also not gone into that.
ٹھیک ہے, اس میں پیرا 19 میں آپ دیکھیے ان کی جو فائنڈنگز ہیں, جو ان کا ریشیو آف دی ججمنٹ ہے, they have held that the election commission has no jurisdiction
Exactly, sir.
the intra party election.
So پہلے ہم نے وہ تھریشولڈ کرنا ہے کراس.
دوسری ہوگی نا, وہ تو کہہ رہے ہیں کہ آپ اگر یہ آپ آرگیو کر رہے ہیں کہ الیکشن کمیشن کو انٹرا پارٹی الیکشن دیکھنے کا اختیار ہی نہیں ہے, تو
جی کہہ رہا ہوں میں نے آپ کو نوٹ کرایا.
You are supporting the judgment of the Peshawar High Court.
I am.
Then you have to show from different provisions of law that
is what I'm saying. اس لیے پہلے میں وہ کر رہا ہوں, then I'll come to this point also.
فرض کیجئے دیکھ ہی نہیں سکتے, تو then there is no question of any election commission.
Exactly. That is your lordship what I'm exactly, that is my point.
لوگوں کا یہ ہوتا ہے نا کہ وہ سیدھے ججمنٹس پہ آ جاتے ہیں. پہلے آپ ذرا سے فیکچوئل چیزیں اگر آپ ہمیں بتا دیں نا, تو پھر ججمنٹ کو اس نظر سے دیکھیں گے. اب آپ ایک ججمنٹ, آپ بالکل بے نظیر کا ججمنٹ ہے, ہمیں پتا ہے وہ ججمنٹ ہے, اس سے ہم ڈس ایگری بھی نہیں کر رہے ہیں, تو وہ کوئی بات کو آگے بڑھائے گا نہیں.
جو
اگر آپ کوئی خاص مخصوص پیراگراف پڑھنا چاہتے ہیں خوشی سے پڑھیے, روک نہیں رہے ہم آپ.
جو جج صاحب نے کہا دیٹ از ویئر آئی ایم گوئنگ فرسٹ. ٹھیک, یہ الیکشن میں دیکھنا,
ایک طرف وہ یہ کہہ رہے ہیں, دوسری طرف کیا کر رہے ہیں وہ بھی پڑھ دیتا ہوں میں آپ کو. کیا کریں, فائنڈنگ ان کی جو ہے نا تھوڑی سی میوچلی ڈسٹرکٹیو لگ رہی ہے مجھے. جہاں انہوں نے یہ ریفرنس دیا کچھ کیس لا کا, وہ کہہ رہے ہیں کہ نہیں وہ کر سکتا ہے, اور دوسری طرف کہہ رہے ہیں نہیں کر سکتا, تو یہ کچھ سمجھ نہیں آیا مجھے. کنٹینیو میں آپ کو بتاتا ہوں, اس کے اندر ایک جگہ ہے
نہیں. اگر میں ایک مفروضے کے طور پہ پوچھ رہا ہوں, آپ کی کیس سے نہیں پوچھ رہا ہوں, کوئی اور پولیٹیکل پارٹی ہے, وہ ایک کاغذ کا ٹکڑا پیش کر دے, دوسرا 200 کاغذ کا ٹکڑا پیش کر دے, ٹھیک ہے, تو یہ کون فیصلہ کرے گا؟
سول کورٹ.
کیوں؟
کیونکہ ممبرز کا آپس میں ڈسپیوٹ ہوگا.
سول کورٹ کہے گا کہ میرے پاس جوریسڈکشن نہیں, تو الیکشن کمیشن کا کام ہے.
الیکشن کمیشن میں تو جوریسڈکشن نہیں ہے نا سر.
یہ آپ کدھر سے بات کریں؟
میں آپ کو لا پڑھا کے دکھاتا ہوں. دیر از نو جوریسڈکشن دے ہے. دیٹ از واٹ آئی ایم سیئنگ. یہ تو سول کورٹ کے معاملے ہیں جب ممبرز کے آپس میں ڈسپیوٹ.
بیک اپ کیجیے نا اس بات.
میں کر رہا ہوں سر, بٹ اف آئی کین پروسیڈ.
7 ہے نا آپ کا ججمنٹ کا, پیج 7 سر ہائی کورٹ کا. اس میں پہلے ہی انٹروڈکشن میں ہی کہہ رہے ہیں, دی پیٹیشنرز ہیو کویسچنڈ دی امپیون آرڈر آن لیگل ایز ویل ایز فیکچوئل پریمائز. However, we are mindful of our jurisdictional contours that the factual finding of ECB regarding the conduct of election cannot be substituted by this court. Therefore, if it is found that the ECB had the jurisdiction in the matter, then in such circumstances, this court had no mandate to interfere in said finding. ایک طرف تو یہ پشاور ہائی کورٹ کے ججمنٹ سے جو امپیون ہے,
بالکل سر میں جانتا ہوں
کہ ہم فیکچوئل میں نہیں کریں.
ہاں, وہ انہوں نے کہا,
اس میں آ کے
انہوں نے کہا کہ پہلے ہم نے یہ دیکھنا ہے, جو ہر عدالت پوچھتی ہے کہ سب سے پہلے یہ دیکھنا ہے کہ جس انسٹیٹیوشن نے آرڈر پاس کیا ان کو قانون نے یہ طاقت دی کہ نہیں.
الیکشن کمیشن کا کوئی رول ہی نہیں ہے نا پھر, تو مطلب یہ
نہیں ہے,
پروب نہیں کر سکتے.
I will show that.
تو پھر کیسے رول نہیں ہے پھر وہ پھر انٹر الیکشن کا جو سلیکشن ہے ذکر ہے,
that is what I will show today.
ذکر ہے کہ یہ الیکشن کرانا ہے آپ نے وقت پہ اور جو کرنا ہے اور آپ نے مانا بھی ہے, تو پہلے پھر
سمپل بات ہے. جی سمپل بات ہے. ایک ایگزامپل آپ کو میں دیتا ہوں. جی دیر از اے پاکستان پینل کوڈ جو کہتا ہے کہ اگر آپ نے قتل نہیں کرنا, اگر کیا تو آپ کو سزا ہوگی. بٹ دیٹ ڈزنٹ مین دیٹ الیکشن کمیشن کین look into that and say کہ یہ سزا ہونی چاہیے یا نہیں. It is the criminal code that has the jurisdiction. So every statement in the law needs a jurisdiction.
Section 208 میں تو الیکشن اس میں لکھا ہے نا,
وہ آتے ہیں سر,
وہ شروع ہی ہوتا ہے کہ الیکشن کرائیں گے آپ.
Let me come to my first point then. ہاں, میں سمبل کیس کو بھی چھوڑ دیتا ہوں ایک سیکنڈ کے لیے.
یہ سمبل کیس تو ہے ہی نہیں ہمارے سامنے. بیسیکلی ہمارے سامنے تو پشاور,
میرے حساب سے اگر آپ نے الیکشن ہو گئے, سمبل آٹومیٹک فالو کرے گا میرے حساب سے. کیونکہ وہ ٹیکنیکل چیز ہے, پھر کیوں آپ کا سمبل ہوتا ہے, ایک الگ ایشو ہوگا نا کہ جی کسی کو یہ لگنا چاہیے, اس نے بھی اپلائی کیا, ہمیں بھی اپلائی کیا, وہ ایک الگ بحث پڑ جاتا ہے.
میڈیا پرسپیکٹو کے اندر جو آپ یہ سمبل کی بات کر رہے ہیں نا, وی ہیو نتھنگ ٹو ڈو ود دی سمبل.
سمبل تو لیا ہم سے.
پشاور کا ججمنٹ دیکھ رہے ہیں یہاں پہ, اور ای سی پی کی
دیکھیے, لیکن ای سی پی نے سمبل لیا نا.
نہیں, ای سی پی کا پہلا خط پڑھیے, انہوں نے آپ کو کہا الیکشن کروائیں.
الیکشن ہم نے کرائے,
متواتر ایک ہی بات ہے نہیں, اور اس میں آپ کو دھمکی بھی دی, اگر آپ نہیں کرائیں گے تو ہم آپ کا سمبل لیں گے.
Question is, can they take the symbol for non-election?
No.
Even if I don't hold election.
No, but you have accepted that letter of ECP. آپ نے ان کو کہا برائے.
Letter does not confer jurisdiction, sir.
No, دیکھیے نا, اتنی تو بات نہ کریں نا. الیکشن کمیشن نے آپ کو, جب آپ کی حکومت تھی, ٹھیک ہے, تو وہ آپ یہ باتیں, میڈیا والی باتیں الگ ہیں, کورٹ والی باتیں الگ ہیں. اس وقت آپ کو خط لکھا, برائے کرم الیکشن کرا لیں. آپ وقت گزر گیا, آپ نے الیکشن ابھی تک نہیں کرائے, نہ اپنے آئین کے مطابق اور نہ پاکستان کے قانون کے مطابق. اگر آپ نہیں کرائیں گے تو ہم آپ کا الیکشن سمبل لے لیں گے. انہوں نے آپ کو دھمکی نتیجہ بھی بتا دیا کہ ہم یہ کریں گے, ٹھیک ہے. آپ نے کہا جی حضور مجھے کووڈ آ گیا, مجھے 1 سال کا موقع دے دیں. آپ نے یہ نہیں کہا آپ کون ہے میرا سمبل لینے والے, آپ نے ہمیں دھمکی کیسے دے دی. بے شک الیکشن کرانا الگ ایشو,
ہر دھمکی کا جواب نہیں دینا چاہیے
بلا وجہ, تو وہ ایک الگ ایشو ہے, ٹھیک ہے. پھر الیکشن آپ نے کیا, پھر انہوں نے کہا کہ آپ صحیح طور پہ نہیں کرا رہے ہیں الیکشن. آپ چلے گئے لاہور, تو پھر چلے گیا پشاور. تو یہ دیکھیں, بنیاد سے شروع کریں نا. الیکشن کمیشن نے کیوں آپ کو کیوں تنگ کر رہی ہے. پھر ہم نے ان سے پوچھا کہ یہ صرف آپ ہی کو تنگ کر رہی ہے. دیکھیں وہ ایک الگ کیس بن جاتا ہے, وہ ہوتا ہے ڈسکریمنیشن کا. انہوں نے کہا نہیں جی, ہم نے تو 13 پارٹیز کو اور وہ کر دیا. ہمارے پاس ایک کیس آیا تھا, اے پی ایم کیا ہے,
وہ بھی دیکھ لیتے ہیں سر, کہ وہ بھی ان کو ڈسکریمنیشن میں آؤں گا, وہ بھی گراؤنڈ ہے میری, ڈسکریمنیشن بھی ہے.
تو لیکن سر آغاز کریں شروع سے.
میں شروع سے کر رہا ہوں سر. فرسٹ پوائنٹ میرا یہ ہے کہ ای سی پی ہیز نو جوریسڈکشن ایٹ آل.
یہ تو کہنے سے تو نہیں ہوگا, قانون کا.
Let us start with the constitution. ٹھیک, سب سے بڑی چیز ہے آئین.
بالکل, اس پہ کوئی دو رائے نہیں ہے سر, شکر ہے.
So let us start with sir the constitution, and اس میں جو پہلا relevant provision ہے is article 218. ای سی پی کو بنایا گیا آئین کے تحت فور سرٹن پرپز, اینڈ جو ریلیونٹ اس کی 2183 میں ڈیوٹیز دی گئی.
2183 میں,
جی
جی.
اور یہ کہا گیا کہ it shall be the duty of the election commission to organize and conduct the election and to make such arrangements as are necessary to ensure that the election is conducted honestly, justly, fairly, and in accordance with law, and that corrupt practices are guarded against. So,
نہیں دیکھیے ایک بات، یہ اسٹیج ابھی آیا نہیں ہے، یہ وہ الیکشن کی بات ہو رہی ہے، جنرل الیکشن کی.
بالکل
یہ جو بات ہے یہ آتا ہے 219E میں.
ٹھیک ہے. سو
یہ ابھی اسٹیج وہ الیکشن والی بات نہیں کر رہے ہیں، وہ تو کیسے کرتے ہیں ہم دیکھیں گے اس کو اور دیکھتے جا بھی رہے ہیں. یہ آ گیا 218E کے زمرے میں آ رہا ہے کہ such other functions as may be specified by an act of parliament.
So your lordship
وہ پارلیمنٹ کا ایکٹ ہے کہ آپ اپنے اندر جمہوریت لائیں، اور یہ بات ہے، اتنی بات ہے بس.
So your lordship agree with me that 218 has nothing to do with intra-party election.
نہیں 219E
218(3) doesn't. Constitution doesn't, right?
I think that it is interconnected, but that's not really before us.
So 218(3) does not deal with intra-party. That's my submission.
ٹھیک ہے.
Now my second submission is that 219, all of it does not deal. E also does not deal with intra-party election. All it says
law that the election.
All it says is exactly. وہ یہ کہتا ہے 219 کہ 218 اور 219 میں انٹرا پارٹی الیکشن میں کانسٹیٹیوشنل پروویژن نہیں ہے. 219E یہ کہتا ہے کہ آپ قانون میں جو طاقت دیں گے.
اگر آپ یہ بات کریں گے یہ آپ کا موقف خراب کرے گا.
اوکے.
پھر اگر آپ کہتے ہیں آئین میں کہاں لکھا ہے سمبل دیا جائے گا، دیکھیے وہ پھر آپ کو ایکٹ سے ملتا ہے. یہ نہ کریں کہ آپ ایسا آرگومنٹ کریں جو آپ کے دوسرے آرگومنٹ کو خراب کر دیں. اچھا مجھے آئین میں دکھا دیں کہاں لکھا ہے الیکشن سمبل ملے گا پارٹی کو.
وہی میں دکھانے جا رہا تھا سر.
بتائیے.
میں ابھی پڑھنے جا رہا تھا ججمنٹ، وہ پھر آپ نے
وہ انٹرپریٹیشن پہ آئے گا.
ہاں لیکن انہوں نے کہا کہ اٹ از پارٹ آف آرٹیکل 17.
پہلے والے لا میں بھی تھے نا انٹر پارٹی الیکشن.
آرٹیکل 17 کا پارٹ تھا. بہرحال اس پہ میں آتا ہوں. بٹ مائی پوائنٹ از دس، آئی تھنک وی آر ناٹ ایٹ ڈفرنٹ ویو لینتھ سر. آئی تھنک پوائنٹ ہم دونوں ایک ہی بات کر رہے ہیں. 219E کے تحت آپ جورسڈکشن دے سکتے ہیں بائی لا. ٹھیک. That is what I'm saying. I think that is what your lordship's observation was. ٹھیک ہے.
یہ ساری باتیں سمبل یہ چیزیں یہ آئیں گی ایکٹ کے ذریعے آ رہی ہیں.
سو کانسٹیٹیوشن میں نہیں پاور دی، یہ کہا ہے کہ آپ لا کے تحت پاور دے سکتے ہیں. Now come to the law. So Election Act 2017 was made under this provision. And 2017 کا سیکشن کا میں الیکشن ایکٹ کا پہلے سب سے ہم پڑھتے ہیں صرف 209.
جی یہ سرٹیفکیٹ کا پروویژن
جی
پڑھ دیجیے.
209. A political party shall, within 7 days from the completion of the intra-party elections, submit a certificate signed by an office bearer authorized by the party head to the commission to the effect that elections were held in accordance with the constitution of the political party, and this act to elect the office bearers at the federal, provincial and local levels wherever applicable.
Elections Act.
I'll read it again, sir.
Now the certificate is made a conditional section.
Yes.
Law.
Yes.
Conditional.
Conditional.
Unless the elections are conducted according to the constitution, the rules of that political party. What does that political party says?
My submission.
آپ نے کون سا سیکشن پڑھا ابھی؟
209.
209.
مگر 207 سے کیوں نہیں آغاز کر رہے ہیں؟ سے 207 پڑھیں. میں نے آپ کو کہا نا وہ تو ایک کانسیکوینس ہے، وہ ایک سرٹیفکیٹ کاغذ کا ٹکڑا آپ کو پیش کر دیں. مگر اصلی سبسٹینٹیو میٹر از یو آر ٹاکنگ آف اے پروسیجرل میٹر. آئی ایم ٹاکنگ آف اے سبسٹینٹیو رائٹ. 207 یا تو کہیں کہ میں الیکشن کروں نہ کروں یہ میری مرضی.
میں ابھی آتا ہوں صرف
نہیں دیکھیں پھر وہ آپ موقف لیں کہ جی میں پولیٹیکل پارٹی ہوں، میری مرضی میں الیکشن کراؤں یا نہ کراؤں، اور یہ جتنے قانون ہیں سارے غلط ہیں. وہ پھر آپ کا ایک الگ موقف ہے.
نہیں میرا موقف
تسلیم کریں کہ مجھے الیکشن کروانا ہے. میرا موقف کیا ہے؟
میرا موقف یہ ہے سر that under the law میں نے الیکشن کرانا ہے, بٹ الیکشن کمیشن جی
یہ 207 کہتا ہے
جی بالکل کرانا ہے,
میں نے تو نہیں کہتا ہے,
میں نے انڈر دا لا کرانا ہے, لیکن میرا موقف یہ ہے کہ اگر الیکشن میں کوئی irregularity ہے تو وہ الیکشن کمیشن کو نہیں اختیار دیا قانون نے کہ وہ اس میں پروو کرے. الیکشن سر میری بات سن لیجیے, الیکشن کمیشن کو اجازت نہیں ملی, اختیار نہیں دیا قانون نے کہ وہ اس میں پروو کرے. الیکشن کمیشن آف پاکستان از ناٹ ٹو اے کورٹ آف لا. اگر کسی کو اعتراض ہے کہ یہ الیکشن نہیں ہوا یا قانون کی خلاف ورزی ہوئی یا اس میں کوئی irregularity ہوئی, تو کوئی بھی ممبر سول کورٹ جا سکتا ہے. دیٹ از مائی کیس بفور دس کورٹ.
ون آپشن ہے, مگر سیکشن 215 کو اگر آپ پڑھیں اس میں پورا میکینزم
میں پڑھ رہا ہوں سر, میں وہی پڑھوں گا.
اختیار نہیں ہے, وہ تو کہہ رہے ہیں کہ آپ کو بلا سکتے,
دیکھتے نا, اس لیے میں اس موقف میں دیکھنے جا رہا ہوں. 209 پڑھ رہا ہوں پہلے میں, 219 سے پہلے سے 209 پڑھوں گا میں. 209(1) پڑھتے ہیں دوبارہ.
سارا جورسڈکشن کا تو ایشو آ رہا ہے نا, یہی تو ہم آپ سے کلیریفائی کرنا چاہتے ہیں.
جی میں کلیئر,
آپ برائے کرم 208 پڑھ لیں.
208 بھی پڑھ لیں,
208 پڑھ لیتے ہیں.
دیکھیں اس کی ترتیب میں پڑھا جائے گا نا. 207 سے شروع کرتے ہیں.
فنکشننگ آف پولیٹیکل پارٹی.
چلیں سر, then in that case let us, because there will be relevance, let us start with 200. جی, فارمیشن آف اے پولیٹیکل پارٹی.
نہیں وہ تو فارم تو ہو گئی, اس پہ تو کوئی ایشو ہی نہیں ہے, تو وہ ٹائم ضائع کرنے والی بات ہو جائے گی نا. فارمیشن تو کوئی وہ نہیں کہہ رہے کہ آپ پولیٹیکل پارٹی نہیں ہیں. ٹھیک ہے, اب ممبرشپ آف پولیٹیکل پارٹی 7
سے شروع کر دیتے ہیں.
جی کریں.
If your lordship says a political party shall have an elected general council at the federal, provincial and local levels wherever applicable and by whatever name it can be referred. ٹھیک ہے, no quibble with that proposition. A political party shall at least once in a year convene a general meeting at the federal, provincial and local level of a political party wherever applicable and shall invite the members of the political party or its delegates to participate in the general meeting. ٹھیک ہے, I have no issues with that. That's the law.
You can't have an issue with anything. It's the law of Pakistan.
But what I mean is that this
you will not challenge them.
But what this does not give the jurisdiction to the election commission.
پڑھ لیں 208 پڑھ لیں.
سے پہلے 200 میں کامنٹ کر دوں اس پہ 207 پہ. 207 does not give any jurisdiction to the election commission کہ وہ اگر پولیٹیکل پارٹی نے کنوین نہیں کی جنرل میٹنگ تو وہ اس کا سمبل ریفیوز کر دے. That is 207 پہ یہ is my comment and my submission. 208 پڑھ لیتے ہیں آپ. 208(1) The office bearers of a political party at the federal, provincial and local levels, wherever applicable, shall be elected periodically in accordance with the constitution of the political party. So this basically says it's a mandate کہ آپ نے جو آفس بیئرز ہیں وہ elect ہوں گے according to the constitution of the political party. But it does not, 2081 does not give the jurisdiction anywhere to the election commission کہ ان کا کام ہے ایگزامن کرنا کہ یہ constitution violation ہوئی ہے کہ نہیں, الیکشن ہوئے کہ نہیں. آگے پڑھتے ہیں سر. ایک چیز لاء میں کلیئر آ گئی. Provided that a period not exceeding 5 years shall intervene between any two elections. وہ انہوں نے لاء نے کہا کہ 5 سال سے زیادہ آپ نہیں کر سکتے.
جی وہی تو وہ کہہ رہے ہیں کہ یہ وائلیٹ کیا ہے آپ نے, 5 سال سے آپ نے الیکشن نہیں کرائے. اتنی سی بات انہیں ہے, بڑی بات نہیں ہے ان کی.
وہ یہ نہیں کہہ رہے سر, وہ یہ کہہ رہے ہیں آپ نے الیکشن کرایا لیکن ریگولر کرایا.
پڑھیں گے نا وہ اسی ایک ہی ان کا دکھڑا ہے الیکشن کمیشن کا, الیکشن کرا لو اپنے پارٹی میں, ختم.
انہوں نے کہا ارریگولر, انہوں نے کرائے لیکن ارریگولر.
نہیں, وہ جب آپ نے کرائے وہ نے آپ کو مسترد کر دیے. جو آپ کہتے ہیں کرائیں وہ پہ کوشچن مارک آ جاتا ہے نا اس پہ.
But they are not to enforce this provision. There's nothing here which gives them the right. 2, a member of a political party shall, subject to the provision of the constitution of the political party, be provided with an equal opportunity of contesting elections for any political party office. ٹھیک ہے, equal opportunity ہے. I can't say کہ women are not allowed. I can't say minorities are not allowed.
جو 14 لوگ ہیں ان کو اجازت کیوں نہیں دی؟
دی جی بالکل دی, یہ فیکٹ میں وہ کہتے ہیں, میں
پوچھ رہے ہیں آپ سے.
بالکل دی اجازت, بالکل دی اجازت. But question is, if نہیں دی, they should have gone to the civil court. All members of the political party, 3, all members of the political party at the federal, provincial and local levels.
کہنا ہے civil court in تربت.
جی
آپ کا کہنا ہے, یہ ذرا سمجھ لوں بات, ایسے آپ نے کہہ دیا نا گو ٹو سول کورٹ, ایسے بات نہیں چلے گی, آپ کو دلائل دینا ہوں گے. سول کورٹ ان تربت can undo the entire election of PTI or any political party because it's a civil court.
Sir, It can, لیکن اس کا امپیکٹ سمبل پہ نہیں ہوگا.
آپ سمبل کو 2 منٹ چھوڑ دیجیے نا, ہمیں صرف الیکشن چاہیے. اگر دیکھیں ایک بات ہے نا, یا آپ تسلیم کر لیں جمہوریت چاہیے یا کر لیں نہیں, لیکن جمہوریت ہمیں گھر میں نہیں چاہیے, باہر چاہیے. دیکھیں یہ بنیادی باتیں, ہم جمہوریت کے ساتھ کھڑے ہیں, وہ آپ کے گھر میں بھی ہو اور باہر بھی ہو, یہ اس کی نکھار ہے, اس کی خوبصورتی ہے. ادروائز تو وہ ویسٹڈ انٹرسٹ آ کے کیپچر کر لیں گے کسی پولیٹیکل پارٹی کو, تو پھر عوام جو ہے, جو عام ورکر ہے, دوسرا ہے, اس کا بھی تو حق بنتا ہے بھائی, ہو سکتا ہے وہ آ جائے, نہیں آ جائے, پھر بھی مطلب اس کو تھوڑا سا یہ ٹالرنس جو ہماری ختم ہو گئی ہے نا, کہ بھائی پوائنٹ اپنا, ہم بھی تو ہمارے عدالت میں بھی تو ڈسینٹ ہوتے ہیں نا, ڈسینٹ کا سرآنکھوں پر, ٹھیک ہے, یہ تو نہیں کہ ادھر دشمنی شروع کر دیں یا کچھ اور شروع ہو جائے, وہ ان کی اپنی ذہانت سے کرتے ہیں. ہمارا تو جمہوری ادارہ ہے بھی نہیں نا, اگر سیاست تو جمہوریت ہے اور کچھ بھی نہیں ہے. آپ کے مجھے سیاست چاہیے مگر جمہوریت نہیں چاہیے, یہ مجھے نہیں سمجھ آئے گی بات. سوری ٹو سے آپ جو بار بار کہہ رہے ہیں سول کورٹ سول کورٹ, مجھے اس کی لاجک نہیں سمجھ آ رہی.
میں یہ کہہ رہا ہوں سر کہ جورسڈکشن
کہنے سے نہیں, کچھ اس کے
وہی دکھا رہے ہیں ہم کہ جورسڈکشن کہاں سے آ رہی ہے, ابھی تک تو نہیں آئی. 3 all members of the political party.
اگر اس کا فنڈامنٹل رائٹ ہے تو پھر وہ سول کورٹ جائے گا.
جی میں اس پہ آتا ہوں. پہلے میں صرف یہ دیکھ رہا ہوں کہ کیا جورسڈکشن کورٹ کو, الیکشن کمیشن کو ہے کہ نہیں. ہم دیکھ رہے ہیں کون سا ادارہ, مقصد ایک پٹواری جو ہے وہ تو الیکشن کمیشن کے فیصلے یا الیکشن انٹرا پارٹی الیکشن نہیں ڈیسائیڈ کر سکتا, کیونکہ اس کے پاس اس کے قانون کے مطابق اختیار نہیں ہے. تو ہم یہ دیکھ رہے ہیں کہ الیکشن کمیشن آف پاکستان کے پاس اختیار کیا ہے جو قانون دیتا ہے, تو وہ میں کوشش کر رہا تھا دیکھنے.
پلیز ریڈ دی فردر سیکشنز.
جی
اب آپ 209 پہ آ گئے.
نہیں سر, ابھی امپورٹنٹ ہے. اب اس کا اسی 208 میں جہاں یہ الیکشن کا تھا, ایک وقت آیا جون میں آف دس ایئر, اینڈ جون میں دس ایئر انہوں نے پارلیمنٹ نے کہا کہ یہ تو عجیب بات ہے کہ ہم ٹھیک ہے, ہم ان کو سپروائزری رول تو نہیں دے رہے اپنے اوپر, پولیٹیکل پارٹیز کو, ای سی پی کو پولیٹیکل پارٹیز پہ سپروائزری رول نہیں دے رہے, لیکن الیکشن ہی نہ کرائیں تو پھر کیا ہوگا. اگر الیکشن ہی نہ کرائیں تو there must be some penalty imposable on them. So an amendment was made.
2 لاکھ روپے کی
جو بھی ہے پارلیمنٹ نے ڈیسائیڈ کی.
جی پڑھی نا, سب سیکشن 5 میں ہی ہے.
سب سیکشن 5 میں ہے of 208, where this was added in 2023 June, where a political party fails to conduct intra-party elections as per given time frame in their constitution, یعنی بالکل ہی فیل کر دے, کرے ہی نہ الیکشن, not irregularity but کرے ہی نہ,
اس کو بیچ میں انٹرپریٹ نہ کریں, پورا پڑھ لیں. سیکشن کون سا پڑھ رہے ہیں آپ؟
سوری 5 سب سیکشن 5 of 208, where a political party fails to conduct intra-party elections as per given time frame in the constitution, a show cause notice shall be issued to such political party, and if the party fails to comply with, then the commission shall impose fine which may extend to 200,000 rupees but shall not be less than 100,000 rupees. So 208 non-compliance, my submission would be they covered.
آپ کا مطلب یہ ہے کہ اگر آپ نے کوئی سرٹیفکیٹ دے دیا, رپورٹ دے دی کہ ہم نے الیکشن کر لیا, تو الیکشن کمیشن ہیز نو رائٹ ٹو سی ٹو دا میٹر کہ وہ پراپرلی ہوا ہے کہ نہیں, یا الیکشن ایٹ آل ہوا بھی ہے کہ نہیں.
اگر دینا ہوتا,
آپ نے نہ کیا وہ الیکشن اور آپ ایک پیپر دے دے کہ ہم نے کر لیا.
اگر یہ ہوتا, اگر یہ پارلیمنٹ نے پاور دینی ہوتی کہ وہ اس کے سرٹیفکیٹ کے پیچھے جا سکے.
اگر آپ اس کو پڑھیں دوبارہ غور سے
5 کو, جی
ود ان ٹائم, جی یہ تو دس از اے ریپ آن دا نکلز کہ جی آپ چلیں, آپ نے 3 سال میں کرانا تھے, آپ نے 3 سال 3 مہینے میں کر, انہوں نے 2 لاکھ کی پینلٹی لگا دی. ٹھیک ہے, یہاں وہ کچھ اور ہے, وہ کہہ رہے ہیں آپ نے الیکشن کرایا ہی نہیں ہے.
فیز ٹو کنڈکٹ سر,
ود ان ٹائم, دیکھیں ویئر پولیٹیکل پارٹی فیز ٹو کنڈکٹ انٹر پارٹی ایز پر گیون ٹائم فریم in their constitution. یہ آپ کا کانسٹیٹیوشن آئین کہہ رہا ہے 3 سال کا, آپ نے 3.5 سال لگایا, ہم کو 2 لاکھ روپے فائن لگا دیتے ہیں. آپ کی بات بالکل درست ہے, مگر اگر آپ دیکھیں نا, آپ کہیں تو پھر آپ کہہ رہے ہیں کہ اگر میں 2 لاکھ روپے دے کر کے الیکشن کبھی نہ کراؤں, یہ انٹرپریٹیشن نہیں نکلتا.
تو میں ایک سینیرو بناتا ہوں سر کہ ابھی 208 میں کم از کم یہ نہیں مجھے نظر آیا کہیں کہ الیکشن کمیشن آف پاکستان can examine کہ ایک انٹرا پارٹی الیکشن پولیٹیکل پارٹی کا درست ہوا ہے کہ نہیں. یہ مجھے 208 میں مجھے نہیں نظر آ رہا.
آگے آ رہے ہیں نا
جی چلیں آگے دیکھتے ہیں. 208 میں نہیں آ رہا.
آپ 209 پڑھیے پہلے.
اب 209 پڑھیے
کیونکہ وہ 2 لاکھ والا اسٹیج تو پار کر گئے نا. اب آپ نے تو الیکشن کرا دیا, اب جبھی تو آپ نے سرٹیفکیٹ دیا ہے, تو وہ 2 لاکھ والی تو بات ختم ہے نا.
تو وہ 208 والی بات ختم ہے. بالکل صحیح,
تو ختم ہو گئی.
دیٹ از مائی پوائنٹ. 208 والی بات ختم ہے.
انہوں نے فائن نہیں لگایا آپ پہ,
نہیں لگایا,
1 سال دے دیا,
میں نے الیکشن کرا دیا. 208 از گون.
Maybe 208 is not a political party in government.
Sir, 208 is not relevant. That is what I am saying. ٹھیک ہے جی. اب آپ 209 پہ آ جاتے ہیں. A political party shall, within 7 days from completion of intra-party elections, submit a certificate signed by an office bearer authorized by the party head to the commission to the effect that elections were held in accordance with the constitution of the political party, and this act to elect the office bearers at the federal, provincial and local levels wherever applicable.
اب یہ اس میں بہت کچھ ہے
جی.
یہ
اب یہ کیا کہتا ہے
1 میں جو ہے 209 میں بہت کچھ ہے اس میں.
ٹھیک ہے, بالکل ہے. اس میں کیا کہتا ہے سر؟ اس میں یہ کہتا ہے کہ پولیٹیکل پارٹی نے 7 دن کے اندر ایک سرٹیفکیٹ دینا ہے. اس سرٹیفکیٹ کے اندر لکھا ہونا چاہیے کہ میں نے الیکشنز کرائے ہیں
ان کے قانون کے مطابق, اور
میں نے آپ کے قانون کے مطابق یہ سرٹیفکیٹ دینا ہے.
فارم 65
فارم 65 یہ سرٹیفکیٹ دینا.
پہلی بات بتائیں, پارٹی ہیڈ کون ہے آپ کی پارٹی کا؟
جو الیکٹ ہوا سر وہ
نہیں 209 والا پارٹی ہیڈ کون ہے؟
the chairman.
نام کیا ہے؟
یہ تو الیکٹ ہوا بعد میں نا, یہ جو
تو بات کی بات ہے نا,
اس میں آیا ہے.
جو الیکٹ ہوگا نا,
ان کا بھی تو الیکشن کوشچن میں آ گیا ہے.
لیکن یہ جو
دیکھیے
اسکیم ہے,
یو آر بیگنگ دا کوشچن. اگر یہ پرانے پارٹی ہیڈ ہوتے, ٹھیک ہے, عمران خان صاحب دے دیتے سرٹیفکیٹ تو ایک الگ بات ہے. یہ خود تو نہیں دے سکتے اپنے لیے سرٹیفکیٹ کہ میں پارٹی ہیڈ ہوں.
اسکیم یہی ہے سر, اسکیم یہ ہے کہ جب الیکشن ہو جائے تو جو بھی پارٹی ہیڈ بنتا ہے
ہر چیز جاتی ہے الیکشن پہ. جی,
جب بھی ہو جائے وہ پارٹی ہیڈ نے دینا. یہ بھی آبجیکشن الیکشن کمیشن نے نہیں کیا. اگر وہ کہتے ہیں عمران خان صاحب کا سگنیچر چاہیے وہ بھی آ جاتا سرٹیفکیٹ میں.
جب الیکشن ہو رہا ہے اس وقت کون تھا, who was heading that party?
عمران خان صاحب.
اچھا,
اصلی کوشچن تو ان کی خود کا الیکشن میں آ گیا ہے نا.
لیکن میرا پوائنٹ وہ نہیں ہے سر, میں وہ آپ کی بات نہیں,
آپ کی پوائنٹ ہو یا نہ ہو,
میں اس
اگر دیکھیے اگر
میرا پوائنٹ
اگر آپ اپنے ممبران کو حق کے الیکشن نہیں دیں, بابا ہرا دیں اس کو نا. ایک جمہوریت اسی کو کہتے ہیں نا.
میں تو ابھی صرف اس پوائنٹ پہ آیا ہوں سر, اس کا بھی
جواب ہمارے ذہن میں جو بات ہے
بالکل میں نوٹ کر رہا ہوں. لیکن ابھی جو میرا پوائنٹ ہے از ریلیونٹ ٹو سیئنگ کہ 1 میں الیکشن کمیشن کو کم از کم کوئی اختیار نہیں دیا کہ وہ الیکشن کو.
تو دیکھیں میں آپ کی بات میں سمجھ نہیں پا رہا ہوں. اگر الیکشن کمیشن کو نہیں دیا تو پھر سپریم کورٹ کو دیا ہے, کس کو دیا ہے اختیار؟ یہ
سر میں وہ بھی بات,
آپ کہیں یہ قانون بے مقصد
وہ اس کو دیا ہے کہ اگر یہ کوئی ممبرز میں ڈسپیوٹ ہو جائے, ایک ممبر آ کے کہتا ہے کہ جناب میری الیکشن نہیں ہوا.
جوریسڈکشن کی بات بتا دینا, کس کو دیا ہے؟
سر کورٹ کو, پلینری جوریسڈکشن آف کورٹ.
دکھا دو کہیں لکھا ہوا ایسی بات.
وہ صرف لکھنے کی ضرورت ہی نہیں ہے.
پلینری جوریسڈکشن کے اندر بڑا واضح لکھا ہوا ہے نا.
میں اس پہ بھی آتا ہوں, پہلے ایک ایک کر کے کر رہے ہیں.
بیسیکلی انہوں نے ایکشن 215 کے تحت لیا ہے.
چلیں اس پہ آتے ہیں, لیکن 209 میں نہیں لکھا.
آپ کا کہنا یہ ہے کہ آدھا جوریسڈکشن ای سی پی کے پاس ہے, جہاں تک ڈیلے ہوا تو انہیں لگا دی 2 لاکھ کی پینلٹی. آپ ایک سے پوری بات سمجھے نا, اور جو باقی جوریسڈکشن ہے وہ کہیں اور ہے. یہ تو بہت ہی اللاجیکل سی بات ہے نا. یا تو آپ بالکل ہی نہ تسلیم کر رہے ہیں ای سی بی کا جوریسڈکشن, پھر وہ آپ پہ 2 لاکھ روپے کا جرمانہ بھی نہیں نکال سکتا ہے. ایک طرف تو آپ تسلیم کر رہے ہیں اس کا جوریسڈکشن, دوسری طرف اس کا جوریسڈکشن آپ ڈینائی کر رہے ہیں. پھر اگر یہ بات ہے تو وہ 2 لاکھ کا جرمانہ کیسے لگا رہا ہے؟ یا پھر آدھا جوریسڈکشن وہ لے گا سول کورٹ اور باقی آدھا جوریسڈکشن.
قانون جو ہے وہ تو بڑا واضح ہے, اور میں نہیں کہہ رہا یہ قانون پچھلے 100 سال سے ہے, اور وہ قانون یہ ہے سر
اس لیے امریکہ نہیں ہوئی.
اس میں تو انکوائری نہیں ہوئی سر.
انکوائری از اے سیپریٹ تھنگ. اوپن پروسیڈنگز کی بات کر رہا ہوں.
اوپن پروسیڈنگز دیکھو, اوپن پروسیڈنگز انکوائری کی ہونی تھی نا. اس میں سرے سے انکوائری نہیں ہوئی.
نہیں, وہ ایک الگ پوائنٹ ہے. پروسیڈنگز اوپن ہوئی یا نہیں ہوئی؟
اس اپلیکیشن پہ کوئی آرڈر نہیں ہوئی. یعنی جتنی پروسیڈنگز,
اس کا نمبر کیا ہے ریفرنس کا, یہ والی موجودہ کا
347
जितने
समझ गया
ओपन नहीं हुई।
So distinguished,
got it. Khatam, can we ask Mr. Salahuddin? We want to wrap it up. Mr. Salahuddin, you've been hearing everything?
I was not able to be to Islamabad because of lack of availability of flights.
What is the way forward? Address that point only.
My Lord, my submission is that the report and the notification is to be set aside on the ground of being malafide in law.
Please tell us the way forward.
Yes, sir. My submission is that it cannot be remanded to the SJC. The SJC scope is limited under Article 209. However, this court, if it considers fit, and I would urge that it
who do you represent? Who do you take secretary? Who do you represent?
My Lord, the Bar Association, Karachi Bar Association, and the Islamabad.
So you basically don't want the truth to come out.
No, sir.
Yes.
In fact, my petition is.
You are saying. Please hear us. You are saying that the relief should be given to the petitioner, but the people of Pakistan should be kept in the dark because they can't handle the truth. So why can't it be remanded? Why are you saying it can't be remanded?
No, not at all, sir. I'm not saying that it should not be investigated. My submission is that the proper forum would either be this court itself or a commission appointed.
We are not seeking your opinion. We are seeking some legal response. In my opinion, that doesn't help us, does it? Why can't it be remanded?
It is because of the language of 209 itself, sir.
Where does it suggest that? In fact, Mr. Hamid Khan has just cited a case where it was remanded, the matter was remanded.
इसमें ये जो केस इन्होंने रेफर किया है इसको डिस्कस करा है
It cannot be remanded. If Mr. Shoukat Siddiqui was still now.
We can't. Voice has gone.
48.
So the council to recommend his removal. Therefore, it does not have then the jurisdiction under 2096. And so the remand right now cannot be done. It could have been done 2 years ago. But right now, the remedy is that uncertainty those allegations.
So you mean to say, on account there is a well-settled principle that no one should suffer as a consequence of act of court. So you're saying because the court delayed the matter for 2 years, the petitioner's valuable right has been taken away from him. Is that your argument?
And
we can't hear you. You're not speaking clearly. करें ना ठीक इसको.
That the civil servants actual tenure has ended.
Civil servant को आपने judge बना दिया. अब आप please don't.
Disciplinary proceedings का principle तो वही है sir.
No, it's not. Please, no, don't do this. If you're reducing a constitutional office to the level of a bureaucratic thing and saying the same principle applies, with respect, I will not agree with you.
My submission is that the stigma around the person's reputation caused by wrongful removal, that is something that he is entitled to remove, even if he has finished his age of service. It is the same principle which your lordships entertain appeals against convictions, even when
Mr. Salahuddin, please focus on the Constitution. Mr. Hamid Khan has read 2095, which says inquiry, then 2096, which talks about inquiry, and you are saying there's no need for an inquiry because he's retired, he's attained age to 62, so even if SJC did not comply with the Constitution, so let him suffer.
Yes, sir. What I am saying this court is to set aside the report of the Supreme Judicial Council and the President's notification on account of being without jurisdiction and then
we are asking you, can it be remanded or not? We're not asking you, can it be set aside?
My submission is the reason the factual allegations cannot be investigated anymore by the Supreme Judicial Council is because
we should. Are you saying that we should take over the functions of the Supreme Judicial Council? That's the only solution. Then there's no other way. Either they do it or we do it.
The Supreme Judicial Council has a specific rule when it comes to this.
Mr. Salahuddin, you're not providing us any solution. You are saying the Supreme Court should assume the functions of the Supreme Judicial Council.
Right, sir. The Supreme Judicial Council will end if a judge, for whatever reason, is no longer there.
Then why are you saying for whatever reason? We are dealing with a real case.
Yes, sir. He has crossed the age of superannuation.
So he should suffer. He should suffer because of that.
No, I'm not saying he should suffer.
I don't know.
I'm saying the order can be set aside
without conducting inquiry. We should set aside the order. Why?
The order should be set aside
without inquiry. No, without inquiry.
Irrespective of the merits of the case, the order is without jurisdiction, therefore it deserves to be set aside. It is without jurisdiction for two reasons. The first reason is that the inquiry was not initiated.
If you are arguing in this manner, what provision of law have you filed your petition under?
184(3).
What's the first word in that? Then you don't have a case. Then we should dismiss your petition on that ground alone, because you're arguing against your own petition now. You are saying you're now claiming the right of an individual and not the public's right. Please read 184(3). It starts with the word public importance. So you are now pleading the case of the petitioner, not the public's. You're not saying exactly what you're doing. You say public should not know the truth of the matter. Please give him his pension and that's it.
So the aspects of public importance.
184(3 पढ़िए ना जी.
So the first aspect of public importance is that whether the SJC has the legal right to remove judges without a factual inquiry. That is a question of public importance. The second question of public importance here, which is separate, is whether the allegations of Mr. Shoukat Siddiqui were correct or not. That has to be investigated separately. My only submission is that the SJC no longer can do so. The reason I am saying this is,
you don't. When you say a statement, back it up. That has to be investigated separately. I'm quoting your words. How? That's the only question we are asking you.
Your Lordships, in 184(3), your Lordships can.
I'm just quoting you. I'm quoting your words. Who will investigate? We. Say, tell us.
The truth of the allegations can be determined by this court.
So we record evidence. We will record evidence. We will record evidence.
There's no bar to it, sir. But if your Lordships feel that
feel की बात तो नहीं हो रही है. You are assisting the court. We don't go on feelings. Assist the court on the constitutional point, not on our feelings.
My lord, there is no bar under 184(3) to recording of evidence. It is done even in constitutional petitions under Article 199.
ये तो आप हमें वे फॉरवर्ड हम बार बार पूछ रहे हैं ना, वे फॉरवर्ड बताएं.
गुजारिश ये है कि it may be referred to a commission.
Sir, if you can speak slowly, we can't hear your words.
Mike से थोड़ा पीछे हो जाए. Mike से थोड़ा पीछे हो जाए.
My submission is that it may be referred to a commission that inquires into the factual truth or otherwise of his allegations. Because I completely agree that the allegations are of such a nature that the public has a right to know whether they are true or not.
Where does the Supreme Court have this power to appoint a commission?
My Lord, the power is 184(3). And
no, don't just say these things. No. Read the language. Where does it say Supreme Court can appoint a commission?
Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article. Now,
now please stop. Go to 199 and say as that the High Court can constitute a commission. If they can, we can.
My Lord,
unless you want us to start writing into words into the Constitution, you can't just say, just throw in something and say commission should be instituted. Commission, the only commission that I'm aware of is Commission of whatever Inquiry Act of 2017,
yes, sir.
Which the federal government constitutes. So where is the power of the Supreme Court to constitute a commission?
My Lord, the mandamus would issue to the federal government.
अब आप कहीं और जा रहे हैं तो आपकी प्रेयर में तो ये बातें हैं ही नहीं ना.
What do you say about 210? Article 210. जरा पढ़े.
For the purpose of inquiring into any matter, the Council shall have the same power as the Supreme Court has to issue directions or orders for securing the attendance of any person or the discovery or production of any document, and any such direction shall be enforceable as if it had been issued by the Supreme Court.
What do you say about when in presence of such a vast powers, why you are reluctant to remand the matter to Supreme Judicial Council?
सर मेरा ये कहना है कि साथ में 209(5) और 209(6) भी देख लिया जाए.
पढ़े.
If on information from any source, the Council or the President is of the opinion that a judge of the Supreme Court or a High Court may be incapable of properly performing the duties of his office by reason of physical or mental incapacity, may have been guilty of misconduct, the President shall direct the Council to, or the Council may, on its own motion, inquire into the matter.
That's the very point we've been saying. Inquire. Admittedly, SJC did not do that. And I'm not following you at all. You're not citing any precedent, or you are just saying, in my opinion, feelings. I mean, let's go on the Constitution. What does it say?
My Lord, the Constitution says that the SJC can inquire into the conduct.
That's the whole point. They did not inquire. That's the case. Hamid Khan's case is.
Yes, if I may explain, sir.
It's not an explanation. It's a fact. Either they did or they didn't. They did not inquire.
This is admitted fact.
Sir, if the SJC report and the President notification is set aside, does Mr. Shoukat Siddiqui automatically become a judge of the High Court? No, he does not. And because he does not become a High Court judge, then the SJC cannot inquire.
At least he will get the status of ex-judge of the High Court. Former judge. He will get the status of ex-judge of the High Court.
Exactly, and there is nothing in 2095 that allows the SJC to inquire into the conduct of an ex-judge. Then if your lordship sees 2096 has to be
at that time, there's a settled principle of law. When a list comes before a court, it has to be decided at what was there at that time. Not aaj law ye ho gaya. Suppose a crime is created today, we will not decide it as today, we will decide it when the law was at that particular time. It's well settled principle, unless specific retrospectivity is given to something. So merely saying these things, we can simply avoid what you are saying, that the list before the SJC, we are considering matters, we're going back, traveling back in time. whether time is moved forward or not, whether he's attained the age of 65, 62, are all subsequent events, coincidental events, which one view is they are very material, that the minute the watch goes forward, 62 is struck out of court. I gave an example, you were not listening maybe, that before he could file a petition, the next day he retired. So he has no remedy, then you can say, yes, he has no remedy. Let's at least be on the same line. I mean, then I can appreciate it if you use the same logic. But you're simply saying because he's retired, that's it. So then he's condemned. You can drag on proceedings, you can curtail a proceeding.
That is the opposite of what I am saying. I am saying that if a person retires...
But we are not talking about if a person, we're talking about a judge. This is not a bureaucrat here before us. Let's use the word judge.
Right. If a judge retires, and your lordship comes to the conclusion that the SJC order was without jurisdiction.
We are not saying that. No. We are not saying that at all. You've not been following. We are simply focusing on one point and one point alone. No inquiry was held. Without jurisdiction, we are certainly not saying, yes, Supreme Court had jurisdiction.
My humble submission is that the lack of a factual inquiry renders those proceedings forum non juris and without jurisdiction. If there are factual aspects that have to be looked at into, and the domestic forum or the SJC doesn't look into it, then that renders the decision of that forum without jurisdiction and malafide in law.
This you are arguing on the basis of a normal petitioner. Then why should we entertain your 184(3) petition? Where is the element of public interest? We will concern ourselves with the petitioner, the judge before us. You have got no concern with the matter then. If this is your argument, if you merely want him, whatever, that the order set aside, how does it benefit or not? Or how does it, for independence of judiciary, transparency, right of information of the public, then you've removed the entire public importance aspect of the case from your case. Then we should not hear you, we should dismiss your petition, we should just hear Mr. Hamid Khan. If you're taking away you're removing all the public element from it. If the public element is removed, then how are you invoking the 184(3) jurisdiction? The same question, Mr. Khan has also come before us in 184(3). On the thing, it's not just me, it's independent of the judiciary. I mean, has the independence of the judiciary been restored because now he'll be entitled to pensionary rights? Is the truth not important anymore?
My lord, it is certainly important, as I have said, but forum is different. But what I am saying is the public importance is there, because if the Supreme Judicial Council removes a judge of a superior court without holding a factual inquiry, then your lordship has to declare that.
You are repeating yourself. Then I don't think you're going forward.
Salahuddin Sahab, ये Supreme Judicial Council Procedure of Inquiry 2005, इसका Section 8 Subsection 7.
जी सर.
वो जरा पढ़ें आप. Without prejudice to the foregoing, the Council shall have inherent powers to adopt any procedure specific to the inquiry which is considered by Council to be just and proper in the circumstances. और उसके बाद मैं आपसे कहूंगा जरा पेज नंबर 48 पे एमपीओ इसका पैराग्राफ नंबर 15 पढ़ लीजिए जरा आप. पेज नंबर, ये हामिद खान साहब की जो पेपर बुक है, इसका पेज नंबर 48 और पैराग्राफ नंबर 15।
जी सर,
ये पढ़िए तो। आफ्टर हियरिंग द लर्नेड अटॉर्नी जनरल,
जी, आफ्टर हियरिंग द लर्नेड अटॉर्नी जनरल फॉर पाकिस्तान and Justice Siddiqui at his learned counsel at great length, the matter was adjourned by the council to 8/10/2018 for deliberating upon the respective submissions and to determine the way forward, keeping in view the peculiar circumstances of the matter at hand. The council met again on 8/10/2018 and the entire matter was deliberated upon from diverse angles. It was pertinently observed by the council that Article 209(5) of the Constitution of the Islamic Republic of Pakistan authorizes the Supreme Judicial Council to inquire into conduct of a judge of the Supreme Court of Pakistan or of a High Court upon a direction of the President of Pakistan or on basis of an information received from any source or on its own motion, and Supreme Judicial Council Procedure of Inquiry 2005 prescribes the mode of conducting such an inquiry.
इनको पढ़ने दें, इनको पूरा मुकम्मल करने दें इनको।
I think, if your lordship, if I may skip a few and go to the about 10th last line of the next page.
जी, आप 10th last line 4th line से पढ़े। इनका जजमेंट का रेफरेंस दिया गया है, जो हामिद खान साहब ने जो रेफर किया है, इसके जजमेंट का रेफरेंस दिया है इसमें। ये पढ़े आप, इसी कंटिन्यू करें इसको आप।
जी सर, जी।
In the case of Justice Shoukat Aziz Siddiqui and
in the case of Justice Shoukat Aziz Siddiqui, the Supreme Judicial Council procedure of inquiry was held by the Supreme Court of Pakistan.
KPLD 2018 Supreme Court 538 इसका रेफरेंस है। जी, कंटिन्यू करें।
जी, to be constitutionally valid and compliant with university accepted principles of due process. In the present matter, initial scrutiny of information was conducted in terms of para 7 of the said procedure of inquiry.
ये जो मैंने पढ़ा था।
A discussion and inquiry into the information was undertaken in terms of para 8 of the procedure of inquiry. A decision was taken to proceed against Justice Siddiqui and a show cause notice was issued to him along with the supporting material calling upon him to explain his conduct. And after receipt of his 2 replies, the council had met and they decided to proceed further with the matter in terms of para 9 of the procedure of inquiry. And thereafter, the Attorney General for Pakistan was required to conduct the proceedings in terms of para 10 of the procedure of inquiry. After that stage of the proceeding, the said procedure of inquiry remains silent regarding the procedure to be adopted or followed in a given inquiry, and the council is extended the necessary discretion to adopt any procedure which may be found by it to suit the requirements of the inquiry. Such discretion of the council is manifestly explicit from the contents of para 8(7) of the procedure of inquiry, according to which, without prejudice to the foregoing, the council shall have inherent powers to adopt any procedure specific to the inquiry which is considered by the council to be just and proper in the circumstances. As the proceeding against Justice Siddiqui were based squarely upon the making of the above mentioned speech by him and the multiple and pervasive allegations leveled by him.
इसमें वो बताना चाह रहे, सलाउद्दीन साहब इसमें बताना चाह रहे कि हमने इंक्वायरी कर ली है। इनका कहने का ये मकसद है कि इंक्वायरी हो चुकी है, हमने अपना प्रोसीजर अडॉप्ट कर लिया। आपसे एक सवाल, आपकी बात अगर तस्लीम की जाए कि इनके हद तक सेटिस्फाइड कर दें, इनका स्टेटस बहाल हो जाएगा, और दूसरे पोर्शन में जो इंक्वायरी आप कहते हैं वो अलग से कंडक्ट हो। सपोज हम आपकी बात मान लें, इंक्वायरी कंडक्ट होती है, उस इंक्वायरी में ये हम ही करते हैं और ये साबित होता है कि इनकी एलिगेशन गलत थी, फिर क्या होगा? इनका स्टेटस वापस लिया जाएगा? कौन लेगा?
सर, इसमें फिर ये होगा कि there would be it would be then before the relevant criminal court perhaps, because there would be a question of perjury, there would be a question of
the ex-judge of the High Court will face the criminal charge without the intervention of the Supreme Judicial Council.
My lord, judges are not above the law.
No, the Supreme Judicial Council, they have to face the consequences through the Supreme Judicial Council.
My lord, with respect, if someone commits the act of criminal defamation,
no, we don't want these analogies which are not applicable to Supreme Judicial Council or to judges. Let's stay focused on the Supreme Judicial Council, on judges and the Constitution. We don't need any analogies. If you can throw any further light, please continue.
No. My lord, I'm not making an analogy with respect, because
please let it go. If you want to contribute, we don't want these analogies.
My lord, this is what is the statement. If the statements are false, then it's not a matter of analogy, then there are consequences for false statements on both sides.
I don't, if I was to deconstruct what you're saying, first of all, it's a never-ending thing ever. Let's take logically what you're saying, as what my lord had put to you, that if the petitioner's this order is set aside on the basis that no inquiry was held, and subsequently a commission, okay, it's magically formed, we go along with that, and the commission, where is the commission? It's not a court of law, it's not a constitutional body, it's a sub-statute body, naturally, or a body created by an order of a court. It can either be one or the other, not a third one. That finding will prevail over the Supreme Judicial Council, will prevail over the Supreme Court, and on the basis of what this inquiry is held, either pursuant to order of the court or the Supreme Judicial Council, a judge can go to jail for perjury. This is the sum total of the argument. I don't follow this.
Let me explain myself, sir. It will not, obviously, the commission, the report of the commission too, does not automatically affect.
Hey, first tell us who creates this commission. You know,
it is formed under the Commissions of Inquiry Act, and if your lordship sees in the act,
so if a commission of inquiry determines something that this judge had not stated the truth earlier, he will be persecuted for perjury.
My lord, it prepares a report. That report is then forwarded to the relevant body.
भैया आप ये बार-बार ये चीजें कह रहे हैं ना, vagueness, relevant body. We are a highest court. We want to know what is this body. Each word you must.
The criminal investigation agency, sir.
So we are then handing over the fate of judges to some SHO or a sub-inspector in police.
If a judge makes a false allegation, he defames someone, commits libel, and it is found to be false, then he should not expect to...
Saudi are not quite getting traction with me, at least. If कोई और बात करें या if you want to file, refer to... You are not, sorry, but you're not referring to any precedent, any law, I mean, these are just opinions stated at the bar. कुछ और हमें बताएं ना, कुछ चीज तो बताएं ना, कुछ आगे बढ़ने वाली बात।
मैं अगर आप इजाजत दें तो मैं थोड़ा सा ये जो पैसे
आप ऐसा करें, आप अपना राइटिंग में सबमिशंस कर दें, बिकॉज हमें समझ नहीं आ रही बात, एंड वी आर maybe you have got better ideas, you can put them in writing and we'll consider them.
May I just summarize the...
No, please do so in writing, because you will carefully think out everything, and I'm sure it will be, because if it's also 10 minutes to 2, आप हमें writing में दे दें, we will certainly consider it. Huh?
जरा आर्टिकल 2095 मैं पढ़ना चाहता हूँ. ये कह रहा है कि if on information from any source the council or the president is of the opinion that a judge of the Supreme Court or of a High Court may be incapable of properly performing the duties of his office by reason of physical or mental incapacity or may have been guilty of misconduct, यानी कि 2095 का A या B दोनों में से कोई एक भी अगर अप्लाई करेगा तो 209 अप्लाई कर जाएगा, यानी कि लफ्ज इन्होंने और इस्तेमाल किया है लॉ मेकर्स ने. बात हुई इंक्वायरी के हवाले से तो बड़ी बात हुई और हमने नोट भी करी, लेकिन मिसकंडक्ट के हवाले से कोई एक बात भी कोर्ट में नहीं की गई. टॉकिंग फॉर माई सेल्फ, ठीक है. तो मिसकंडक्ट के हवाले से अगर देखा जाए तो ये जज साहब जो थे जिन्होंने जो बातें तकरीर में करी हैं, डोंट यू थिंक दैट दिस फॉल्स अंडर द एम्बिट ऑफ मिसकंडक्ट एज पर आर्टिकल 2 जो कि कहता है कि केयरफुल टू प्रेजेंट डिग्निटी ऑफ द कोर्ट, और आर्टिकल 9 जो कि ये कहता है कि ही शुड वर्क फॉर द इंटेग्रिटी ऑफ द इंस्टीट्यूशन ऑफ जस्टिस. नाउ व्हाट आर द इंस्टीट्यूशन ऑफ जस्टिस? Institution of justice are high courts and the Supreme Courts. तो इन दो आर्टिकल्स के हिसाब से आपका क्या ख्याल है कि ये जो पिटिशनर साहब हैं ये मिसकंडक्ट के जुमरे में नहीं आते हैं? अगर थोड़ी देर के लिए हम मान भी लें कि इंक्वायरी वाला एस्पेक्ट जो है वो रह गया था सुप्रीम जुडिशियल काउंसिल से, लेकिन ये जो एस्पेक्ट मिसकंडक्ट का है वो स्क्वायरली अप्लाई नहीं करता है क्या पिटिशनर के केस के अंदर, स्पेशली इफ व्यूड अंडर आर्टिकल 2 एंड आर्टिकल 9 ऑफ दीज रूल्स? तो इस एस्पेक्ट के ऊपर हमें कोई असिस्टेंस नहीं मिली है माजरत के साथ। इंक्वायरी के हवाले से तो जरूर हमें मिली है कि ये इंक्वायरी नहीं हुई और इन लोगों को बुलाया नहीं गया, लेकिन वी हैव नॉट बीन प्रॉपर्ली असिस्टेड, टॉकिंग फॉर माई सेल्फ, विद रिगार्ड टू द एस्पेक्ट ऑफ मिसकंडक्ट जो कि आर्टिकल 209 के बी के अंदर फॉल करता है और जो कि साफ साफ कहता है कि अगर मिसकंडक्ट होगा तो आर्टिकल 209 लगेगा। इसके बारे में आपका क्या कहना है सलाउद्दीन साहब?
मैं जरा ऐड कर दूं माइलॉर्ड की बातों में। क्या जो तकरीर की थी वो मिसकंडक्ट में आती थी? यस। उसके लिए इंक्वायरी जरूरी थी? यस
सर, मेरी दो सबमिशंस होंगी इसमें। फर्स्ट ऑफ ऑल, if what he said in his speech was factually incorrect, then it was misconduct. If it was not factually incorrect, if he had correctly stated the facts, then it was not misconduct, number one. Number two, sir, the other reason why it was necessary to assess whether the allegations were true or untrue was because it would affect the proportionality issue. If, for example, all these allegations were correct and the only grievance was कि ये आपने public speech में नहीं बातें करनी थी, तो then perhaps the SJC, the proper course for the SJC would not to be to remove the judge altogether. The punishment also has to meet the crime and doctrine of proportionality. जनाब ने अपनी कई judgments में
नहीं Saraudin साहब, I understood your first point. As far as your second point is concerned, there is no other option. ये तो नहीं है कि इस साल इंक्रीमेंट नहीं मिलेगी या दो withholding pays हो जाएंगी. Either you remove a judge or you don't remove a judge. Full stop. There is no proportionality involved in 209 at all. I don't know where you're getting this proportionality element and introducing it into the SJC. Rap on the knuckles, be a good boy, don't do it again. You know, that they can't do. Either they dismiss the complaint or they sustain the complaint and give a finding of misconduct and recommend his removal. That's all. Where's proportionality? Where are you getting this from in 209?
My Lord, the court can certainly not give a lesser punishment. Your Lordship is absolutely right. It's not a court,
it's Supreme Judicial Council we're talking about.
Yes, sorry, the Supreme Judicial Council, sir. The SJC cannot give a lesser punishment, and your Lordship is absolutely right. The question is whether the misconduct complained of is serious enough to justify removal. Your Lordship will appreciate that the Code of Conduct says, for example, that a judge should not be rough in his conduct. Complaints are made against judges that they are rough in their conduct. On those complaints, the SJC would not be justified in actually removing a judge for misconduct because such a penalty would be disproportionate to the complaint made. Because if your Lordship sees the Code of Conduct...
You then agree, you agree with us, na? Then, okay, we got it.
जी सर। अब सर एक और
जी
जो effect है, and
the offer of filing something you're not availing, you want to conclude, it's up to you.
Sir, there's just one point that I would ask that your Lordship hear me on. It'll take 2 minutes, sir. It'll take 2 minutes. If your Lordship just sees the order, the report of the SJC, page 8.
Page 39.
Ji, sir. Your Lordship sees that the first note is sent by the Secretary of the SJC.
Have you seen that already, Ji?
He is the complainant. Number 2 में अगर आप देखें सर, the chairman of the council passes an order that the Chief Justice of the Islamabad High Court may comment upon veracity of allegations.
जी, Mr. Khan has already referred to it. जी
sir. इसमें sir, the chairman of the SJC has directly started the inquiry
without assigning the matter to SJC.
ये अगर आप प्रोसीजर भी देखें, रूल्स 4 to 9 and of course 209 का 5 and 6, article 209 का 5 and 6, the SJC chairman has no role to play in terms of starting the inquiry. The inquiry has to be started by the Supreme Judicial Council. What is calling for a report from the Chief Justice of the Islamabad High Court and for evidence from Mr. Shoukat Siddiqui, that itself was the inquiry. That is an act fully without jurisdiction, and the entire superstructure based on that falls, sir.
Anything else?
My lord, I'll file my written note, sir.
Okay. Anybody else wants to say anything? We'll wrap it up.
एक चीज मैं जनाब की तवज्जो दिलाना चाहूँगा, particularly his lordship's answer, very specific in this judgment of 2018. Page 569, what are the minimum standards of due process under Article 209? वो चंद लाइनें मैंने पढ़ के सुनानी है आपकी.
Where from? ये
PLD 2018 Supreme Court 538.
अच्छा आप ही का केस जी.
538.
रेलेवेंट बताएं. पेज बताएं. Relevant page.
Relevant at what page do you want to read from?
569.
569.
आपके सामने 569
जी.
अब 69 जो आपके सामने है जी सर. सेकंड लाइन से पढ़ना चाहूँ. There is no serious dispute.
Mike, Mike.
There is no serious dispute between the council appearing before us in this behalf, as none of them did or could have confessed that the procedure to be adopted by SJC can be unfair or unjust. This is obviously essential in order to ensure security of tenure of the judge, which is, as already stated above, is the primary purpose of Article 209 of the Constitution. The controversy perhaps pertains to the standards of due process which need to be observed and whether the SJC procedure of inquiry 2005, more particularly paragraph 13 thereof, meets such standards. There also appears to be consensus amongst the learned counsel, learned Attorney General for Pakistan and learned amicus curiae that except for the disputed paragraph 13 of the SJC procedure of inquiry 2005 and the remaining procedures compliant with the universally accepted principles of due process, including as reflected in our Constitution and the various pronouncements of this court. Now this is very important. The judge whose conduct or capacity is the subject matter of proceedings under Article 209 of the Constitution is issued a notice informing of the allegation against him. He is afforded a right of hearing. The findings are based on evidence. So this is most important. Based on evidence which are recorded in his presence. He is also afforded the right to cross-examine the witnesses and produce evidence in his defense. He has right to be represented by a counsel of his own choice. These are the basic elements of due process given by this honorable court that SJC has to follow. So there cannot be any finding given by without evidence, and that evidence should be recorded in his presence with an opportunity to cross-examine. None of that has been done in this case. So therefore mere show cause notice means is neither.
Mr. Hamid Khan, Article 10A has been incorporated in the Constitution, but the principles enunciated in Article 10A have been applied even prior to the incorporation of Article 10A. But now Article 10A is very much part of the Constitution. It has raised it to the level of a fundamental right.
Right.
Due process and fair trial.
That's right.
Now, I'm speaking for myself. The point, I mean, even if you have to remove a Naib Qasid, there is a whole procedure. I mean, that is an employee of the government, not a constitutional office holder. And if surely the requirement should be higher, not lower, than for removing a Naib Qasid. I mean, I would imagine it should be. And then otherwise, what's the worth of a constitutional office if it's not protected at all? So we have to see the Constitution as a whole. We cannot disregard fundamental rights. We cannot disregard the fact of the absence of an inquiry. If in the absence of an inquiry someone is exonerated is one thing, but if in the absence of an inquiry a person cannot be punished. I mean, I think these are the things which are quite clear and obvious. Now, the problem which is at least agitating my mind, and I want you to submit if you all can do so, is where does the Supreme Court draw its line as the Supreme Court of Pakistan not to encroach upon the domain of the Supreme Judicial Council. The Supreme Judicial Council may do some sort of inquiry. That's not the case before us, whether it was sufficient or insufficient. Here there is no inquiry.
No inquiry.
Unless the speech is in itself so offensive that it merits immediate removal. That's one aspect. The other is, if we read the show cause notice, is very much premised on institutions' integrity and institutions being maligned. So everything flows from it. You cannot disregard the content of the speech. Now, the content of the speech, there can be two things. It could have been misunderstood. That's not the case here. The question is it what the judge is saying correct, or what the judge is saying not correct? You are saying it's correct, they are saying it's not correct. We wanted to hear their point of view. Yes, I did say this, I did meet him, but for a different purpose, whatever. That's not the case. No meeting, I never spoke to you, I never said anything. Now, we can't throw a coin in the air and decide who's right. Nor can we, which brings for you opened the door of 184.3. It's not a civil petition for leave to appear or a civil appeal where our jurisdiction is wide and we can do whatever we want to. Now, my understanding of 184.3 is you have two hurdles you have to overcome. Matter of public importance. If you start asserting individual rights, which Mr. Salahuddin was trying to explain to the point that he's removing himself from the domain of 184.3, otherwise it may be a very good case. So if you come before us under 184.3, then it has to be a matter of public importance. And your rights, you have to link with the fact that removal, if it becomes so easy to remove a judge, then independence of judiciary as a whole is under threat.
Yes.
That's I accept. But if you only say, my removal is wrong, maybe you won't meet the test of 184.3. The next part is for seeking the enforcement of a fundamental right. Now, which is the fundamental right? Article 10A, maybe some other article as well, 25, I don't know, whatever you say. But so that's the thing. Where does the public, once we bring in public interest, public also has a right to know the truth. I mean, it shouldn't be perceived that we protect our own when they don't deserve protection. That's very important. Because this is really in the public domain. So, okay, fine, so the public will say, but did he say it or not? Was it true or not? That's the question I was asking Mr. Salahuddin, and he was not coming up with that because he's actually taking his petition out of the domain of Article 184.3. Maybe it's all very new because these questions have just arisen during the course of the hearing. So we've given him time, and we'll also, and the last point is, where do we go from here? One is remand. Can we do it or not? He's saying once you retire, it's over. The learned Attorney General has referred to some other case and says, till that case is not decided, you should not decide this, or words to this effect. So if you can submit a note on these legal points, we'll reserve it. After, if we require to reconvene again, we will reconvene again. But otherwise, consider this, if my colleagues agree, for reserving the judgment subject to, we may want to reconvene after the notes come, or we may have more questions. I don't know. So is this clear? I mean, Khwaja Sahab, you agree with this course of action, or you can also submit as a note, because not necessarily, you said you're not invested in the outcome, you're more interested as counsel. Now we're calling upon you, senior counsel. You can assist this court. The same applies to Mr. Wasim Sajjad Sahab. He's also very senior counsel. So he also said, I need time to absorb the matter.
With your Lordship permission, I'll submit a written note on legal issues. That
you may. Yes, please leave the facts aside.
Yes, that is
completely out.
We're not going into
at all. Don't mention anyone. No. Just on these issues. If you can, if you want to, you may. We're not directing you to.
No.
Because you're not a party.
Yes.
But we felt that things were said behind your back, so you had the right of audience, which we've given you. So, which Hamid Khan Sahab also agreed. आपने post नहीं किया था ना इनका notice. इनको इशू करना हमने नोटिस आपने पोस्ट नहीं की थी ना ठीक तो कितना वक्त आप लोगों को चाहिए होगा to come up with some sort, because this is actually not only this case, every case creates precedent, but in these matters precedents are very rare. I mean, very few come, and this point is a novel point, and you said this, it's never happened that no inquiry has been conducted. Now we want to just see whether, I'm not doubting your statement, but Mr. Salahuddin and Mr. Khaja Haris Saab may tell us no, there are other cases where also inquiry were not held. We would want to know what is the world practice, whether it can be done without an inquiry of the nature that you're setting. We want to know about freedom of expression, of what judges can and cannot say. Because one is, even Khwaja Sahab was not very confident on which particular misconduct it is. Publicity, so that allegation was not leveled. First allegation should have been leveled, you were seeking publicity. So anything else you want to say, please do so. Otherwise, this will be, we'll consider it reserved. ठीक है, लिख लें आज कोई है लिखने वाला ऑर्डर, आप इसमें लिखें.
2 weeks time. Sir, I need only 1 week to have a comprehensive note on.
देखिए आप आजकल जरा बहुत सारे केसेस आ रहे हैं, and all of them require a lot of thinking and detailing. So we'll certainly give you more than a week. It's not that. इसमें लिखिए, we've heard the notices were issued to General Lieutenant General retired Faez Hameed and Brigadier retired Irfan Rame, and
he's not retired, my lord. We corrected that. He's still in service.
Okay, and Brigadier Irfan Rame. Is he still a brigadier or is he?
He's still a brigadier.
And Khwaja and senior counsel Khaja Haris has entered appearance on their behalf and states that he's filed CMA numbers 267 and 268 of 2024 attending to the allegations leveled against them by the petitioner. So full stop. Learned Senior Counsel Mr. Wasim Sajjad states that he represents Justice Muhammad Anwar Kasi, former Chief Justice of the Islamabad High Court, and has filed CMA number 253 of 2024, attending to the allegations pertaining to him.
3 CMS filed.
Huh? एक से काम नहीं बना वसीम सजाद साहब चलें वो लिख लीजिए full stop. Notice was also issued to the former registrar of the Supreme Court of Pakistan, Mr. Arbab Muhammad Arif, who has filed CMA number 270 of 2024. ठीक है, full stop. Next paragraph लिखिए. We've heard Mr. Learned Senior Counsel Hamid Khan for the petitioner and Mr. Salahuddin Ahmed for petitioner in CP number. आपकी कौन सी है Salahuddin साहब? हाँ? 15 आपकी CP का नंबर क्या है?
I'm sorry, my lord.
What's your CP number?
15 of 2020, constitutional petition.
15 of 2020.
20.
एक और भी है apparently. And two CPs number 2 and 15 of 2020.
221 की है.
अच्छा 221 की अलग नंबर चेक कीजिएगा प्लीज. ठीक है, full stop. We've also heard Mr. Learned Senior Counsel Messrs. Wasim Sajjad and Khwaja Haris. और कोई तो नहीं, यही सब हो गए. Full stop. And the Learned Attorney General for Pakistan. Full stop. Assisted by मलिक जावेद असिस्ट किया था या उन्होंने आपको असिस्ट किया? अच्छा, मलिक जावेद. फुल स्टॉप. नंबर ऑफ फुल स्टॉप. असिस्टेंस इसमें लिखिए लीगल लर्नड काउंसिल में सबमिट देयर concise statements.
Written synopsis.
Precise. My lord adds precise and concise. Statements with regard, amongst others, to the following queries which arose during the hearing. Colon. फिर आप इसको 1, 2, 3, 4 कर लें. Whether an inquiry was conducted by the Supreme Judicial Council, and if not, was it a constitutional or legal requirement, and if it was, the consequences of the failure to do so. Question mark. Whether, if the consequence of doing so. Number 2 लिखें. The consequence इसमें लिखते हैं whether that since in the interregnum, that since during the pendency of CP number 76/2018, CP number so and so लिखते हैं was filed on, कौन सी तारीख को फाइल हुई थी? 76
October 2018.
वो डेट ले लीजिएगा. 18 October 2018, and the petitioner attained the age of 62 years
30th of June 2021.
On 30 June 2021, whether what, if any, how can the matter now be attended to if if the petition is to be allowed, okay, if he is to be granted, allowed, if he is to be granted relief, including whether the matter can be remanded to the Supreme Judicial Council. Anything else? Whether there was no need to conduct an inquiry by these SJC, as the speech admittedly given by the petitioner in itself, making of the speech in itself constituted misconduct as defined in the judges, वो पूरा नाम लिख दीजिए, code of conduct. ठीक है? Anything else you want to add?
Sir, in addition to response to these questions, I may kindly be allowed to give the propositions, my propositions.
हमने लिखा amongst others, वो बाकी आप जो मर्जी लिखना चाहें, मगर ये चीजें अटेंड कर लें. अच्छा, full stop. हाँ, precedents भी दे दीजिएगा. हमें लिखने की जरूरत तो नहीं है ना?
Everything.
ठीक है.
Comprehensive.
So these three you attend to. The rest, whatever you want to add, we are not stopping you. But just keep it sort of more precise. Not, it shouldn't be legal drafting. It should be point.
Thank you.
Thank you very much. It's been a learning experience also for us. जो ख्वाजा साहब, अच्छा हाँ, कितने within how much time to be given आपको?
I think two weeks. If your lordship wants.
हाँ, 3 हफ्ते दे दें. नहीं, legal issues है ना.
Quite right.
So, you know, we don't want to say something in a, अब इतना वक्त गुजर गया तो 1-2 हफ्ते अगर वो खान साहब नाराज ना हो कि जी 3 हफ्ते अब दे दिया. ठीक है, खान साहब 3 हफ्ते ठीक है? 3 हफ्ते ठीक है?
सर 2 हफ्ते ही काफी होंगे सर.
तो ख्वाजा साहब 3 मांग रहे हैं, 3 कर लें. वैसे भी ये इलेक्शन वाला हफ्ता तीसरा हो जाएगा ना फिर.
ठीक.
हाँ, तो ये इलेक्शन के बाद ही जाएगा मेरे ख्याल में. अच्छा, इसमें लिखे कंसाइज स्टेटमेंट्स टू बी फाइल्ड विद इन 3 weeks. In case after judgment is reserved, however, in case after examining the concise statements and the available record, a further hearing is required, the court will convene. We don't know what you're going to say, and some of the things I have not read that were filed today and yesterday. Sure.
Acceptable to the government of India. Well, that is the British government. This again emphatically suggests that the government was never accepting an institution formed by a particular religion. Then later by Sir Harcourt Butler to the Raja Sir Mahmud Khan, conveying the decision of the Secretary of the State regarding the Muslim University at Aligarh. In the letter, Sri Harcourt Butler points out the Secretary of State has decided, after mature consideration, that the proposed university shall not have powers of affiliation outside the locality in which it may be established. He also conveyed that the Chancellor could be elected and that the powers which it was proposed to vest in the Chancellor should be exercised by the Governor General in Council, with one exception, namely, the professor should not be appointed without previous approval of Governor General in Council. The Raja of Mahmudabad writes to Sir Herbert Butler and states as follows: there is undoubtedly very strong opinion that objection to word Muslim is being taken by many as part of the policy of Christian nations on to crush Islam. We suggest Aligarh Muslim University, and should Hindu University materialize, we suggest for the Banaras Hindu University. These names naturally grow out of existing names of Mohammedan Anglo-Oriental College and Central Hindu College. And unless there are objections of overwhelming weight, we think it a concession that might well be made to the local sentiments, that let both of them retain their respective Hindu and Muslim names so far as name of the university is concerned. Then, my lord, next, 26th Mohammedan Educational Conference at Lucknow. My lord, this resolution is on record. President Major Sayyid Hassan Bilgrami, in his address to the conference, observed that the decision of the Secretary of State in transferring powers from the Chancellor to the Government of India resulted in practically making the university a government institution instead of a communal one. Well, these are all factors your lordships would bear in mind. But whether I succeed or not, that's not the issue. These are the factors which must be brought to my lord's notice. Please see, my lord, the resolution. This meeting views the decision of His Majesty's Secretary of State as contained in the letter of the Honorable Sir Harcourt Butler, dated Simla 9th August, with profound disappointment and regret. Having regard to the views expressed by the Constitution Committee, and in this Constitution Committee of Constitution of MAO, not our Constitution, in the course of discussion amongst others, 1, that the name of university should be the Muslim University. 2, with regard to the control, the powers proposed to be vested in the Chancellor should not be vested in the Governor General in Council. This precisely happened thereafter. Then 3, the powers mentioned in clause 5, chapter 3 of the statute should be the same as conferred on the patron, it should be patron under section 41 of the rules and regulations of trustees of Aligarh College. 4, this was also not followed. With regard to affiliation, the statute should remain as proposed. And 5, the provisions of the Constitution relating to the powers of the court, the council and the Senate should not be modified. This was modified. I'll show that when the act, my lord, is brought to your lordship's notice. And further, having regard to the momentous issues involved therein, this meeting appoints a committee of the following gentlemen with full powers and authority to act and finally settle all matters relating to Muslim University in such manner as may seem proper to them in the best interest of the community, and to wait in deputation of His Excellency the Viceroy to make all necessary representation in this behalf. Then, my lord, next date, 6th August 1930, the Muslim Gazette, which recorded the meeting of the Foundation Committee at Aligarh, indicated that a group within the committee was willing to accept unhesitatingly whatever form of university that the government was willing to offer. Then 15, demi-official letter from Mr. H. Sharp to Sir Harcourt Butler indicated that while the proposed university would be called the Aligarh Muslim University, its setup as regards control would be along the lines of Banaras Hindu University. Banaras Hindu University had full control of the British government. Lord H. Sharp, my lord, if your lordships can just note down, he is Secretary Education to the Crown. Okay. To the Viceroy, I stand corrected. My apologies, my learned friend Mr. Vivedi is right. Secretary to the Viceroy. Then 24th September 1950, demi-official letter by Sir Harcourt Butler to Raja Sir Muhammad Ali, Muhammad Khan Bahadur. In this letter, Sir Butler indicates that the acceptance of government's proposal as regards the question of principle, such as control, etc., over which there has been prolonged discussion with connection with Hindu University, is an absolute condition precedent for further action. There would be a government control. Take it or leave it. Then October 15, at a meeting of the Muslim University Association, the organization votes to accept the proposal of the government for a university on the same lines as Banaras Hindu University. Then resolution of the Muslim University Committee. The following has been observed: having regard to the refusal of the government to grant to Mohammedans a university on any principle other than those granted to Hindus, this meeting of Muslim University Foundation Committee has no other alternative at present but to accept the principles of Hindu University. Lord, kindly note the Banaras Hindu University Act came into force on 1st of October 1915. Immediately thereafter, my Lord, they also say that, all right, we withdraw all our demands and we are happy if it is given in line with Banaras Hindu University. Then, my Lord, next, 27th August 1970, in a meeting between Aligarh Muslim University Regulations Committee and Education member Mr. Shankaran Nair, it was stated by Mr. Nair that if the government was to recognize the degrees of the college, it would also want control over standard setting in examinations. This was accepted by the Regulation Committee without objection. Members of the Regulation Committee themselves agreed to the appointment of the University Vice Chancellor being subject to veto of the Government of India. They stated that the reason for this was that the university was meant to be all India in character. It was stated as under. The reason assigned for this preference both here and in other places was that the Government of India would be free from local prejudice and that the university will be an all India institution. Sir Shankaran Nair said that Governor General in Council would act only on the advice of local government, that it would actually be to the advantage of the university to place these powers in the hands of the Lieutenant Governor, to whom they could have access and whom they would more easily be able to persuade, as indeed the Banaras University had just persuaded the Lieutenant Governor to reverse the course of action decided upon by himself and the Government of India. He also said that things were tending towards local autonomy. The members of the committee said they would prefer to wait until the time arrived. Then, my Lord, notes of H. Sharp, Secretary Department of Education, Government of India, while discussing the draft constitution of the proposed university. Lord, please, my Lord, allow me to read this. Lord, this would have bearing, my Lord. General principles which should regulate the organization of the university. I suggest two, which should be kept in mind during further negotiations. A. 1. The Banaras precedent should be followed